Honorable Justice Ouko, we are now ready to start our interview. Our candidate today and who has joined us here is Justice Ouko, William Okello. Welcome, Judge, to the interview.
Thank you. Thank you, Chair.
Yes. I think there will be a session of taking photographs and then you start the session. Maybe just a minute. I think that is enough. Thank you. Your Honor, I will request the commissioners to introduce themselves to you, and I'll start with, on my right, with Acting Chief Justice.
Good morning, my Lord.
Good morning, my lady.
I'm Philomena Mbetamwilu, the elected representative of the Supreme Court to this commission. I'm also the Deputy Chief Justice of the Republic of Kenya.
Thank you, my lady.
Good morning, Judge.
Good morning, Commissioner.
I'm Patrick Shohi, representing Public Service. Karibu.
Thank you.
Good morning, my Lord. I'm David Majanja, Judge of the High Court, representing Kenya Magistrates and Judges Association.
Thank you, my Lord.
Good morning, my Lord. I am Oluwande Evelyn, Chief Magistrate, the female representative of KMJA.
Thank you, Your Honor.
Good morning, my Lord. My name is Machari Njero. I represent the Law Society of Kenya.
Thank you, Commissioner.
Good morning, Judge. My name is Felix Koske. I represent the public. Welcome.
Thank you, Commissioner.
Morning, Mr. President.
Morning, Lord.
My name is Mohamed Warsame. I represent you others and the others in the Court of Appeal in this commission. Welcome.
Thank you, my Lord.
Very good morning, my Lord, Judge President of the Court of Appeal, Kehara Kariuki, the Attorney General, here by virtue of my office.
Thank you. Thank you, Mr. Attorney.
Your Honor, I'm Olive Mugenda, Commissioner representing the public and also chairing these interviews. Welcome.
Thank you, Chair.
We also have Honorable Anne Amadi, who is the Chief Registrar of the Judiciary and Secretary to JSC.
Good morning, Judge.
Good morning, Your Honor.
Also, we have Frida Mukaya, who is the Registrar of JSC at the corner there.
Thank you, Your Honor.
So once again, welcome, Judge. A few housekeeping issues. Please be precise in your answers as much as you can so that we can manage time. And I'm also asking my fellow commissioners to also be precise in their questions and also keep within the timelines that we have decided. Your Honor, feel free to ask for clarification if you're not sure or if you didn't hear the question properly, so that you are able to answer the questions properly. After 2 hours, we are going to take a break, and Anne Amadi will come for you to take you where you're going to have your break. Or maybe you can even go to your office because it's around here.
Yes.
Okay, so you now start with the interviews. And I'll start, Your Honor, by asking you a question. We have read your very impressive CV. You have done a lot of work for judiciary the last 30 years. And in 10 minutes, because the rest of the details will come through the questions, but in 10 minutes, please summarize why this commission should nominate you for the position of CJ.
Thank you, Chair. Thank you, Commissioners. I joined the judiciary 34 years ago in 1987 as a district magistrate, professional, that's what they were called those days. In those 34 years, I have risen through the ranks to become a judge of the Court of Appeal where I am today. 3 years ago, my colleagues in the Court of Appeal identified me to be their captain and unanimously elected me as their president. As I steer the Court of Appeal, I'm pleased to tell the commissioners here that the court, despite the numbers which we are all aware of, has done a great job under my leadership. The court has been able to put in place case management systems that has seen it reduce the backlog in that court. When I took over, there were 7,000 or so appeals pending. 2 years later, they were down to 4,000. We had and finalized 3,000 through active case management. Unfortunately, the numbers kept dwindling. Unfortunately, COVID-19 came, and these numbers have started rising, heading back to 7,000, 8,000. The Court of Appeal, under my leadership, is regarded as one of those courts that are most collegiate, where judges work together. There's chemistry in the way we work. The Court of Appeal is also known for delivery of robust decisions. But all this has been because of my leadership, because when I took over, we identified as a court the gaps, one of which was the backlog at the time, the delays in judgments. We had judgments that had been pending from our court up to 3 years undelivered. We took a deliberate decision together that all those judgments we sat in June of 2018, April 2018, and we agreed that by June 2018 we must have all those judgments delivered. So when we assembled in June again to review, we noted that we still had a few left. The judges had worked really, really hard to reduce the backlog of delayed judgments. So we extended time to August, and by August, all those judgments were delivered. As I speak to you today, commissioners, there is no delayed judgment in that court. Perhaps 1 or 2, 5 months or 6 months, again through leadership of myself. How did I get to the Court of Appeal? And I want just to add that when I was elected by my colleagues, I was not the senior most. In a list of 20, I was number 13 in terms of seniority. In terms of age, perhaps the same number. And so they saw something in me that they identified with, that they thought would make a difference in the court, hence the unanimous decision to pick me as their leader. And I want to trace my journey to the Court of Appeal from the time I joined in 1987 as a district magistrate. As a district magistrate, again, I was identified, having worked only for 1 year, working in this very building as a district magistrate and dealing mainly with criminal cases. The chief magistrate at the time, Mr. Justice Mango, identified me to head the traffic court. And he told me in particular that that court had had problems of integrity. Each time a magistrate was posted there, it became a toll station. And he said, I want you to streamline it. He made me in charge of that court. He asked me to ensure that more traffic courts are established in Nairobi and its environs, and I did that. 1 year later, while still a district magistrate, I was promoted my second year in the judiciary to the position of resident magistrate. Hardly had I done a case than I was called by a team of JSC members, just two of them, Mr. Justice Nyarangi, who was then in the Court of Appeal representing that court to the Commission, and Lady Justice Joyce Alwach, who was representing the High Court. When I got a call that I was required to go before them, my reaction was panic, because I didn't know why I was required before the Commission members. With them was Mr. Justice Mwera, who was then the Registrar of the High Court. That's how they were called, a misnomer, because the Registrar of the High Court was really the Chief Registrar of the Judiciary at the time. With them again was Mr. Jacob Olekipuri, who was then the Deputy to Justice Mwera. And I was told that the two had their hands full as administrators. The more we were expanding, but the administration only had two people to help the Chief Justice, so they wanted a third hand. The truth of the matter was that Mr. Justice Mwera was being elevated to the High Court, and Mr. Jacob Olekipuri was taking over as the Registrar. So they picked me as a deputy to Mr. Jacob Olekipuri as the Deputy Registrar. Working in administration, which I did for 17 years, exposed me to many things. While serving as Chief Court Administrator, which was the highest at the time, actually had just been created, I was the first person to occupy that office, and two others did after me, or three others. I was exposed to many things in the court system. I made so many reform initiatives that we enjoy up to this day as a judiciary, and I just want to give a few examples. The medical scheme we are having today, it was my brainchild, and this is how it happened. I'll be very brief. As judges, magistrates, and other judicial officers and staff, we were being paid a medical allowance or up to the standard of your cadre, all put together under the printed budget came to something like 20 million. And then we had also a line called ex gratia medical, which came to about 30 million. I worked out these figures. We commissioned a healthcare provider, and I approached PS Treasury with these figures of 50 million, having consulted very widely among our colleagues, and I traded off. I said, take away the medical allowance that is in our salary, and take away the ex gratia vote, and we get a medical cover. And we started off with one officer alone, first year. The second year, an officer and a spouse. It has grown today to an officer, a spouse, and I think 4 children. Per diem that we today receive when we travel on official duties, again my brainchild, because of the demeaning manner people were surrendering impressed. You are given 10,000 to go to Kisumu on official duties. You only spend 3, but when you come, you have to account for 7. And you'd see all manner of receipts. It was quite demeaning even for judges. And if you didn't surrender, then of course next trip you would not go. Again, I negotiated this with the PS Treasury at the time, and they changed it to per diem that we enjoy today, so you don't have to account every a day is costed, and if you go for 10 days, you're paid equivalent. Apart from those two, in administration, I also took part in many reform initiatives. I was appointed a joint secretary to the Kotut Committee by the President of the Republic, the late Daniel Arap Moi. And Kotut Committee was formed to delink or to address issues of terms and conditions of service of the judiciary. The Kotut Committee made a report that completely delinked the judiciary from the mainstream civil service. The judiciary, for years from independence, was an appendage of the Attorney General's chambers. All our staff, all secretaries, clerks, executive officers, all were seconded from the Public Service Commission to the judiciary. With the Kotut Committee and the report, this came to an end, and we adopted, so to speak, those who are seconded to us. Hence, that's the time we started using PLS 1, PLS up to I think 12 or 13, which have now been converted under your organization review. And that's how we delinked completely from the mainstream public service. The other thing we wanted to do after the Kotut, I was part of the implementation committee that was to implement this, was to completely identify our needs. And one of those needs was to try and have our own pension scheme, away from the one that is enjoyed by the civil servants. I will, if you ask me later, I'll be able to say more about this. I then was appointed as a secretary again to work in the famous Quach committee, again dealing with issues of judicial integrity. Again, after that, I was part of the implementation team that was implementing the recommendations. Finally, I worked, a meeting was called by the then Minister for Constitutional Affairs, the late Mutula Kilonzo, with the Chief Justice at the time, Honorable Mr. Justice Gisheru, and Emeritus Attorney General Amos Ouko. Of the Court of Appeal judges at the time, a few High Court judges, and Law Society, and many players in the justice sector, the issue was reform. At the time, reform was in the air. This was after the Kriegler Commission and all that. In that meeting, again, I was perhaps the youngest and perhaps the most junior. I was asked to chair a task force that was appointed to look at the reforms in the judiciary. That task force was multi-sectoral. The current Speaker of National Assembly was a member. The Honorable Mr. Justice Lenaola of the Supreme Court was a member. Senator Okongo Mogeni was my vice. And I can go on, and it was multi-sectoral. Apart from myself and Mr. Justice Lenaola, most of the members were from outside. We did our work, and that work is reflected in Chapter 10 of today's Constitution. This commission, as constituted today, was recommended in that task force. And so many other things that are in that chapter came from the task force. So, Chair, I believe that with my qualification, that with my training in court administration, with all the things I've done to bring change to the judiciary, that I'm capable of moving this institution from where,
these great ideas not to be implemented fully.
Thank you. Correct observation. The two Chief Justices did great jobs. Chief Justice Mutunga laid a very firm foundation on issues of access to justice, built many courts, opened up the engagement, employment, and appointment of judges and staff. He did a great job in this institution. And Chief Justice Maraga picked from there and has also done great things. He has brought a sense of independence to all of us who work in the judiciary. But as you said, each one of them came with a blueprint, building on each other. And these blueprints, when you look at them, Mr. Justice Mutunga's blueprint, JTF, has 4 pillars, which are more or less replicated in the 6 pillars in Mr. Justice Maraga's SJT. Reform process is indeed a process. It is not a one-off thing. Even those jurisdictions that have developed, they have gone stage by stage. But I think really a critical look at the implementation of the reports, I do not see a focused approach. I think there's a bit of distraction because we are coming up with too many other things. If you look at the policy documents that we roll out, which are all meant to further these reforms, I think they take us off. And I think we need to really, really focus on those recommendations that are aimed at enhancing access to justice. So I would say that we need to just focus and, of course, prioritize those that are low-hanging fruits and those that are medium-term as well as long-term. Once we identify them, we should be able to see the movement clearly. But as it is now, there are many, many things happening around us, very useful things. Perhaps the coordination. I thank you, Chair.
Your Honor, you have talked of focus and coordination. Money was not an issue that we should maybe also address?
Thank you. Yes, money has always been a big issue ever since. Even when I was the accounting officer, money has been a big issue in the judiciary. Just to digress, up to 2003, just before I was appointed a judge of the High Court, the budget of the judiciary was 800 million. We had not reached $1 billion. Out of the 800 million, we were expected to raise in appropriations in aid 300 million. The Exchequer was therefore giving us only 500. This has really grown, really grown. It's to some of us who worked in the judiciary in the early days, this is really a dream come true that now you can talk of 17 billion to the judiciary. But the judiciary has also grown in numbers and in activities. And so money is very critical in reform. Thank you.
Thank you, Your Honor. How would you describe your leadership style? Are you democratic, maybe too democratic? Are you authoritative? How would you describe yourself as a leader, Your Honor?
I am very democratic. And my colleagues in the court will tell you, no decision is taken from my office alone. Just to give you one example, everything we do in that court is done as a team. I'm just a leader. We looked at the number of applications pending in our court, 1,700 applications. Some were filed 4 years ago. Applications for stay, for injunction, simple applications. We, after I identified the problem as the team leader, I assembled the judges and staff, and I told them this is the problem. I knew what I wanted. I wanted us to clear this backlog of applications. And proposals came from the floor. We want to hear these applications. Can we list? Normally we list only 4 applications. I wanted to push them a little to list 6. It came from the floor that we list 15. Again, it was reviewed to 9. And we went out, and in 16 days, we had done 600 applications. And results are out there, rulings delivered. One thing, again, we agreed as a court is to borrow what the Supreme Court has adopted. The applications, you don't have to do 13, 15 pages. These are applications that are run of the mill. And so we agreed we would reduce the number of pages, and we were able to achieve. So through consultation, through teamwork, the court has been able to work together and gel very well.
Thank you, Judge. There are no times when you put that authoritarian hat at all.
Oh, yes. Sometimes you cannot, even as a democratic leader, there are times, a time comes when you have to insist that what you think is best for the team is what has to be done. And sometimes, yes, I do.
Thank you. My last question, Your Honor, is again checking your CV. I noticed that you are a member of the Judiciary Honors Committee since 2018. And one of the candidates that we have interviewed this week, Your Honor, said that there's no criteria, and if it is there, it's not well known, which determines or which, so that one is able to predict who qualifies for that award. So my question is, again, look at your CV, Your Honor. I realize that you got the Elder of the Burning Spear, EBS, in 2019, and also got the higher one, which is the Order of the Chief of the Burning Spear, in 2020. That is 2 very heavy honors in 2 years. So in 2 consecutive years, because there's nothing wrong with the honors. I think you deserve them. But then when they come in 2 consecutive years, my question is, much as you may be deserving your honor, was this due to your membership of that committee, or how did that happen? And number 2, could you have given a chance to one of your other colleagues in the judiciary who deserve to get this honor, so that you don't get 2 of them consecutive? And I'm saying this, Your Honor, knowing that you don't give the awards yourself. Your committee was recommending, but I'm just thinking that it looks a bit odd that you are honored 2 consecutive years. Maybe you can explain to us.
Thank you. Yes, Chair. I am a member of the Honors Committee that is chaired by the Honorable, the Chief Justice. We have only had 2 or 3 meetings. There's an Act of Parliament that deals with honors, and there's a criteria that is used to award honors. And we are just advisory as a Judiciary Honors Committee. We forward names which are received from different courts, different divisions, from different cadres to the National Honors Committee that I think is chaired by the Deputy President. It is there that they now choose who to give. And so it's not, we make a recommendation. Why I ended up with the 2? One, because it was realized that the honors that had been given earlier was lower than the level a judge ought to be given. So we made a case for the judges of the Court of Appeal because they're the only ones who are getting that lower grade. So when we sent the names afresh to be given those honors, only myself and I think Mr. Justice Kiagi got the higher one. I don't know how they picked the two of us and left the rest. So it's not that I used perhaps my membership in the committee to do this. This is, perhaps it's not very transparent also. We simply write to the courts, to the directorates, to nominate those they want to be awarded these honors. And from the list, we don't make any amendments, we send it as it is. Amendments are done in the National Committee. And we give everybody a chance. In my court, a secretary got because she's outstanding in her work. Thank you.
So if you became CJ, it is an area that you would want to work on so that hardworking judges and judicial officers also get these honors. It is something you would want to improve, maybe come up with a criteria, maybe people can apply if they feel that given certain qualifications or achievements they deserve. Is it something that you might want to change?
Yes, because I don't know how each unit identifies those to be brought to the committee. We need to make it also very transparent from those units that everybody in the court, if it's magistracy, let all the magistrates know that this is happening this week and we are nominating those we think have distinguished themselves. And so it is something that should be given as a reward for some achievement and not for any other consideration.
Okay, I think I'll add there, but just a disclaimer, Your Honor, that some of us have those two awards. My only problem was the consecutive years, so, but
Yes.
you have explained, and thank you very much.
Thank you.
I now request Acting CJ to continue with the questions.
Thank you. My Lord, just before we leave that point of the honors, you have described to us what you've done in your long service in the judiciary. Is it not true that the Chief Justice has in fact never chaired any of the honors committees, and that in effect you are actually the chair, my Lord?
I can't say that the Chief Justice has never chaired. The retired Chief Justice asked me towards the end of last year to chair on his behalf, and I've chaired 2 meetings. So I do not know. That was really my first interaction with the committee, so I can't tell whether there were earlier meetings.
No, I'm talking. This is important because not only did Judge raise it, you know there are mamas in the institution. You live here, don't you? So you know what our people have been saying about those honors. So I think it is a topic that we ought to make closure about, and this may be the opportunity.
I agree.
Emeritus Chief Justice Maraga, for the last 2, actually for the 4 years that he was here, he did not chair an honors committee meeting. He always delegated that to judges, and you are one of the judges to whom chairship was delegated in the last 2 years of his term. That's my concern, because I want to ask one other question on the issue. Is that correct?
Yes, as I said, I really do not know the circumstances under which the retired Chief Justice asked me to chair. I thought it was a temporary thing. I didn't know, because under the Act, He is the chair.
He is the chair under the Act. Let us confine ourselves to the period you were chair. He never chaired during your membership, did he?
No.
No, he did not. And therefore, that would be a serious place to start reform. You agree?
I do.
As Chief Justice, my Lord, you would be the Chief Judge and the Chief Administrator of the institution of the judiciary. Is that a correct statement?
True.
Let for now our concern remain with the Chief Administrator. You appear to have got to administration quite early in your days in the judiciary, correct?
Yeah, true.
As early as?
1989.
Since then, you've been, my Lord, in internal leadership of the institution of the judiciary. Now, being specific to yourself, forget the committees out there. Please tell us what your specific contribution has been to the benefit of the institution internally. I heard what my Lord said about the pension. I heard what my Lord said about the medical. But this institution is concerned with more than those two. My Lord would agree?
Yes.
So, as regards, and I heard what my Lord said about being president of the court for the last 3 years, and what the court as a team is doing under my Lord's leadership, correct?
Sure.
So now, my Lord, would you give us specific achievements under the two heads, administrative and judicial, for that period, my Lord?
I said I have served in administration for 17 years. And in administration, your duties are confined to the management of the court, staff, provision of tools of trade, facilitating the judges and staff. And as I said earlier, for administration, there is a lot that I did. I just mentioned two. I can also add pensions, as you've raised it. We started following the issue of pensions in the 90s. And there's one thing that has remained as a scar in my heart, that we've not been able to bring it to closure. But I'm pleased to say again that there's a lot that was achieved also. The magistrates and staff, magistrates and the other staff now have a separate scheme from the public service scheme. Is a contributory superannuation scheme, and that was as a result of my work in the committee that was looking at it. It is that committee that made a proposal to the Retirement Benefits Deputy President and Designated State Officers Act that introduced an amendment to include in that act, because it was taking so long to get the judges' pension running, to include the Chief Justice and the Deputy Chief Justice in that act. My contribution as a magistrate was really brief. I only rose up to RM. And when I became a High Court judge, I believe my decisions, when I was fasted to Malindi, I made decisions regarding the purpose and objective of using assessors in criminal trials. And I made a very strong case that it was not useful if the courts were not going to use their opinions to arrive at a determination of a criminal trial. And I believe as a result of that. I saw more or less a few years later the use of assessors in criminal trials were deleted from our statutes. A very useful thing, something, if you asked me, we can go back to, but make their opinion useful rather than just have them there give an opinion that you can rubbish. I made decisions regarding when I was in the High Court, regarding the use of confession before magistrates. And I thought that to confess a crime before a magistrate who is presiding in a criminal case was to take a magistrate to be part of the investigating team. I thought personally that it was not in order to call a magistrate to go before another magistrate under a trial within a trial to say that I did not torture, I did not promise. I made a decision to that effect. In Nakuru, I made another decision that has gone all the way, Malindi, to your court, Supreme Court. This is a wildlife-human conflict, where I made a decision that it is the role of KWS to ensure that wild animals remain where they belong, and that if they escape and harm human or interfere with human activity like agriculture, then KWS is responsible, a decision that was upheld. In the Court of Appeal, I've also made my contribution in the jurisprudence of that court, and I have shared with the commissioners some of my decisions, among very many others.
Thank you, my Lord. As Chief Administrator, my Lord will be required to ensure that there is full implementation to the greatest extent of the policies that guide the way the judiciary does things, and to improve from where we are at, right?
Yes.
Now listen to this. The principal judge of the High Court is a lady. The principal judge of the Employment and Labor Relations Court is a lady. The Chief Registrar of the Judiciary is a lady. The acting president of the Court of Appeal is a lady. The acting Chief Justice of the Republic is a lady. I hope, by the way, my Lord, that the two acting ladies may be acting, but I hope they are not playing with their duties. That said, my Lord, the gender audit report, which I am sure my Lord has interacted with,
yes,
met with a lot of dissatisfaction from the female constituency of the judiciary, that there are no ladies. It wasn't that there are not enough, there are no ladies in leadership positions in this institution. Would my Lord very briefly discuss that?
Do what? Sorry.
Would my Lord very briefly wish to say something about the audit, the gender audit report?
Thank you very much, my lady. CJ. We are blessed to have the only person you forgot to mention, my lady, is the CRJ.
I did.
Oh, you did. Thank you. And the registrar of the commission. And so the list goes on and on.
We're talking about the judiciary, my Lord.
Thank you. So that audit report to me has acquitted the judiciary in terms of its gender sensitivity, because it is nearly 50-50. The ladies are, I think, 49 point something, and the male 50 something percent. And so I think, compared to the other branches of government that I believe are struggling, look at the executive, look at parliament, I think we are far ahead of the rest. And I want just to commend the Commission for bearing in mind this very critical aspect of our lives today, to balance. And I have no doubt at all that in those positions, the ladies are delivering, just like men would. They are ladies. For instance, your ladyship, you have been able to hold this fort. You call us as JLAC for meetings to make decisions. We have seen, we have had any gap at all. You can't know that the actual Chief Justice retired and somebody is acting. The same thing in the Court of Appeal, where Lady Justice Wanjiru Karanji is acting in my place. I don't receive a telephone call from her to ask me, how do I do this? Because she has a free hand, and I think she's done a great job so far.
My Lord, allow me to say this. The concerns from our female constituency, my Lord, is this, that they are not enough, and I don't think JSC has a role in this, unless I'm mistaken. There are not enough females in top leadership positions in our institutions. So, as Chief Administrator, how would my Lord the CJ promote that? Because I think it's also fact. Okay, fine. Go on, my Lord.
I do not have statistics of the other levels. I know the High Court, I think we are doing very well, just like in the Court of Appeal, the judges, and even the staff. But I do not have statistics of gender in the magistracy and in the other administrative arms, the directorates and the staff. But there ought to be a way of seeing that everybody has equal opportunity. And if we realize that in some areas there's imbalance, is to balance the imbalance.
Thank you, my Lord. Or in fact, is it not true that we are all over the place in the institution of the judiciary? It's just that we don't communicate sufficiently. Isn't that one of our greatest challenges? And how would my Lord CJ improve that? Because the dissatisfaction will continue for as long as things are being done opaquely. Does my Lord agree?
I agree, my lady, fully. We are too hierarchical to begin with. We sit in our corners and forget there are other people around us. The Supreme Court does its thing, the Court of Appeal its thing. We are just all of us, my lady has said. There's need really, as a family of the judiciary, to have a way of communicating. We have had good and bad times. We have had colleagues who have departed. Again, we do not see any coordination. People just do things in their personal way. And I think really there's need for us to unite.
And so, what is my Lord going to do to correct this situation as Chief Justice Ouko? That's what we're looking for.
Thank you. We have in every station leadership and management teams. Through these teams, we can be able to communicate. We have the Judiciary Leadership Advisory Council, which needs to coordinate all these teams to work together. That council, I can say, has done a great job also. Even during COVID, the council has been giving directions together with, of course, NCAJ. But that council perhaps needs to be expanded, in my view. There are people who can offer some leadership in the council. And so what I'll do is to ensure that the synergy between the teams on the ground and the council at the headquarters.
Thank you, my lord. Let's go to the second issue under that topic, and it is this, my lord. The 2010 report on the task force on judicial reforms proposed that there be a separation between the judicial function and the administrative function. Would my lord please tell the commission where we are at currently with that? What role my lord has played up to now, and what role my lord will continue to play as Chief Justice, giving specific recommendations on how to attain optimum results from the separation.
Thank you, my lady. For many years, the magistrates and judges who are heads of stations were doubling up also as the administrators. And so before a magistrate or a judge goes to court, he or she has to deal with issues of leaking roof, issues of discipline, a broken car. And so much time was being taken off court work for administrative duties. That report, that recommendation your ladyship has identified was to address that, to take away the magistrates and judges from the corridors, from the yard, to go to court. I'm aware that we now have administrators in the stations who are helping with administrative work so that the judges and magistrates can concentrate on their core business. As to what part I've played, of course, since I moved to, because that report, after it was made, then I moved to the Court of Appeal. And so my contribution would be confined only to the Court of Appeal. And just to say that those devolved functions for administration have been quite useful, and we've been able to use those officers who have been sent to our various courts. And they have really helped in easing. We have the supply chain officers in our courts, and they've been quite useful to us. And I think I can say that we now have indeed taken away magistrates and judges from the corridors and from the loans.
Thank you, my lord. Is my lord aware of the implementation of the OG review process ongoing?
Thank you, my lady. I would have said that that has really gone a long way, looking at even the proposals, the harmonization and the rationalization of the structures, the work that has happened. I believe that under the Honorable the CRJ, there's a team working to sensitize the staff. I can only say, like most of the things that happen in the judiciary, the judges are normally not quite involved. And so I hope that as they sensitize the staff and everybody else, that they'll remember to sensitize us.
My Lord, we've had committees since your days. You are properly an insider. That's correct, my Lord?
Yes, I am.
That is what you are. We've had all manner of committees around here. Do you know what has happened lately about those committees? And what is the involvement flowing from what we've just been discussing of judges and magistrates in that aspect?
Thank you, Milady. There have been too many committees. I've lost count. There was a time, perhaps there were like 2015 and
42?
42. Incredible. I really don't know what they were doing, and it concerned me that for every little activity there would be a committee. It concerned me. And it completely adversely affected the main work we do in the judiciary. A lot of time is taken in these committees, and I know that they have all now been collapsed. They have been reduced. I can't remember the number. I think there are 7. 6. Which, to me, my very honest view, may still be too many, because in my court alone, I think, save for myself, who is not in any of those committees, and maybe 2 other judges or 3, most of them are in those committees. And the way the committees meet sometimes in the course of the week can affect our core function.
And so, my Lord, will do something about that. I think it's fair to say here, we have nearly almost removed everybody who is a core deliverer of access to justice from those committees, save for just 1 judge, 1 magistrate, max. We've removed all the others, and these reports are available, except, of course, for the statutory
committees.
Now, this institution has been talking transformation since 2011. When will we do transformation and stop talking transformation? And how long is enough?
Thank you, my lady. We started with the word reform, and then 2010, going forward, we moved to transformation. But my lady, transformation in the judiciary, or reform in the judiciary, started much earlier. The RAM2 report, the Mbithi report. There have been many reports. The Quach report, Nyango Tieno, my lord, Mr. Tony, the Kehara Karaoke report. There have been many reports. There has to be an end to more reports. And as I said earlier, reforms are progressive. We've reached a point where we have enough reports. It is time now to implement.
And so what, sorry, my lord?
Go on, yes.
So what would my lord do to make us achieve a most effective implementation?
The 2 main blueprints currently that I think have subsumed most of the recommendations in the previous report is the starting point, our strategic plan. As I said, in order for one to move as a leader, you must get views. And so I have my own view, which is we must move and have results. When Chief Justice Mutunga took over, it is said our backlog stood at 1 million cases pending. As CJ Maraga retired, we are, I think, at 700,000. And the focus should be that, because what Mwananchi wants us to do is to give expeditious determination of cases. And that will be my approach. I know what Mwananchi wants. Go to any court, Kerugoya, Busia, meet any litigant in the court corridors. Ask them, what is one thing that disturbs them? I keep coming to this court. I've come to this court 5 years, 6 years. The focus should be instant delivery of service.
Thank you, my lord. This institution has been trying to operationalize the institution of tribunals, which are part of the judiciary. I think it's Article 169 or thereabouts.
Yes.
Might my lord know, one, what challenges we have met there, what success we have achieved, and what my lord would do. In fact, the import, let's take it this way. First, the importance of the tribunals, the challenges we have faced, my lord, any successes, any, and whether the discharge of function of the tribunal is a distortion of the core mandate of the judiciary as regards alternative dispute resolutions.
Thank you, my lady, again. Yes, tribunals are described in the Constitution as subordinate courts, and so they ought to be part of the judiciary. Tribunals are important. They are specialized. The rules of procedures are not as strict as those of court, and so they dispense justice faster. It is so believed. Tribunals are become fashionable. Again, I've lost the number. I don't know whether they are 60 or 70. It's become fashionable for any legislation to have a provision for a tribunal, which is a good thing, as your ladyship has noted, as part of alternative ways of resolving disputes. We've faced challenges with the tribunals because the transition has been long. I believe there must be some resistance. If I was given the power to appoint people to positions, and this power is being taken away, I'll definitely, as a human being, may not be very happy. So I believe there's some resistance. I'm aware that we've made strides. There was a committee, I think chaired by my Lord Mr. Justice Ntoinoti, that made recommendations to the Commission as to which tribunals can move. And I believe with the recent decision by Mr. Justice Mrima, that we ought to finalize this as soon as possible. Looking at even the arguments before him, the Attorney General didn't seem to have serious resistance or problem with this process being moved. The main issue appears to be the legal framework, and I'm aware that there is a bill 2019 which ought to be fast-tracked. And so I think the first thing that I would do, if you honor me, is to fast-track this bill so that we can be able to have them in. Tribunals are important, and that's why Kenyans in the Constitution thought that they are part of dispute resolution mechanisms and systems. And so they help us with these 700,000 cases. There would be more if tribunals were not there. So they play a critical role, my lady.
Thank you, my lord. Save that they are not the alternative justice systems. They are mainstream judiciary. And so the alternative dispute resolution mechanisms are those other ones, the arbitrations, the mediations, the JSC. And the question still remains whether the alternative dispute resolution mechanisms may distort our core mandate. May they?
No, I don't think they'll complement.
They'll complement. Let's go to something else, my lord. And it is this. The magistrates, you, my lord, will agree, carry the greatest load of enabling access to justice in the institution. Is that a correct statement?
True.
Where are their decisions reported?
Yes, the magistrates are the first port of call. They are the face of the judiciary. Perhaps 90 or 80% of Kenyans who come to court end up there. They make decisions. Unfortunately, the law establishing the Council for Law Reporting does not seem to recognize that. I was a member of the National Council for Law Reporting at its inception, and it's something we discussed, and it's something I think needs to be discussed further, because it is imagined that when magistrates make decisions, they are decisions that can be overturned immediately by the High Court, or confirmed by the High Court again, but overturned by the Court of Appeal, and therefore they do not have any binding effect. But something we were discussing in the council was whether they could have their own way of having their decisions reported. But again, for what I've just said, because those decisions can go up to the Court of Appeal, perhaps even to the Supreme Court in some instances. So why would we have different levels? What we do normally, even in the Court of Appeal, when you cite a High Court authority, we ask you, and I believe you do this also in the Supreme Court, we ask the person citing it whether that decision stands or whether it has been overruled or confirmed. Because sometimes people cite authorities that suit them, but authorities that may have been overruled. And so all I would say is that for that reason, that eventually the decision that will be binding are those decisions of the superior courts on the magistrates' courts, that it would be, I don't want to say a waste of resource, but it would be superfluous to have another law report.
My Lord, the NCAJ, which my Lord will be chair of, has not found it prudent to have decisions by the courts that discharge nearly 80% of the work we do. Last I checked was 70. Is there a gap? And so, what is my Lord Chief Justice? As Chief Administrator, I'm remaining there. Will shortly move to Chief Judge. What is my Lord going to do? Is it not important that the work that magistrates do should be reported, and if it is not reported in Kenya law, should it not be reported some other place, my lord? Or is that what you're saying, we should not have another report?
Sorry, my lady talked of NCAJ. I got a bit confused, but I got the question. Is the Council for Law Reporting?
It is actually under NCAJ. That's the work of my lord as chair there. All these other bodies feed into that body, isn't it? And so, my lord, the direct question is that Kenya law, because of what reason, by the way, has decided that the work done by the magistracy should not, has so far not been reported. Okay? Is that a gap? Is that a good thing? And if it is a gap, then what would my lord do to fill that gap? But if my lord feels that it's okay the way the situation is, then you discuss with us.
I reiterate, there are many good decisions. I just shared with you some of my decisions when I was even a magistrate. And so there are many, many good decisions that come from those courts. They ought to find a place somewhere. But I think the issue is the law. The Act, I think, foresaw only superior court's decisions. So it's a matter, perhaps, I'm not quite sure what, I can't remember now. If it's a matter of the law, then the law has to be amended.
Yes, it's my lord's role as chair, as chief administrator of the judiciary, that my lord would play towards getting this, I think, big gap being filled, whether by amendment of the law, whether by some other form. That's what we're looking for. Let's go to what I think is my last part, second last actually. My lord, as Chief Justice, would be chair the Judicial Service Commission. My lord would be chair NCAJ, and my lord would be all over the place, so to say, a minimum of 5 places. I call them 6 because of the rules function, and so many others that are not under statute. Now, that is time consuming and would require very serious time management, planning how to utilize one's energy to still remain relevant in each of those many roles. Would my lord please tell us what prepares my lord for multitasking, and which role my lord considers as the most important of the many hats my lord would wear as my lord Chief Justice?
Thank you, my lady. Yes, 5 very critical roles, very, very critical, head of the judiciary and all that. They are all equally important and must be given equal priority and chance. What prepares me to juggle this is the background that I've given you, that as registrar of the courts, I was able to wear more hats and was able to deliver without losing my head. As a registrar, you are an accounting officer doing a budget, defending the budget, accounting for expenditure. You are also what they call, I don't know whether it is still relevant, you are also the authorized officer dealing with HR matters. You are in supplies, as we called it then, a library, and even outside the country, you are a member of some community in a committee in the East African community. I went through all this, so my training, my experience and background prepares me to be able to wear these hats.
And to wear them effectively, my lord.
Yes, yes, my lady.
I don't feel that I should leave this area before we discuss just three, which are the most important priorities we have identified for moving us to the next level in our strategic plan on the core mandate of the judiciary 2019-2023. Would my lord kindly discuss very briefly those and tell us how my lord will ensure that we get there?
Thank you.
On the core mandate.
In the strategic plan, I think the strategic plan identifies 8 key areas. The first one would be on access. Access in its very broad term, opening up courts, making work efficient, delivery on time. The second one is on issues of integrity, the strengthening of the Ombudsperson's office that has been identified too. And of course, there's the issue of leadership, enhancing responsive leadership in the judiciary.
On access to justice.
Honorable CJ, I hope you are winding up because time is going.
All right.
Thank you.
On access to justice, which is core, and on organizational sustainability, which also is core, and on the corporate identity, which is also core, I would imagine that one of the very serious issues we would have to settle would be this problematic caseload, how to manage it, so that we remain relevant. My lord, as you hear, we've run out of the time allocated to me, but let me ask one final question. Judicial discretion. What is it? When may it be misused? And is my lord aware of instances of misuse of judicial discretion? And my lord, I wish you the best.
Thank you, my lady. The judicial discretion is the inherent power given to a judge or a judicial officer in law, in the rules, to make a decision. I know that in many instances we have properly exercised our discretionary powers, but I'm aware something that concerns me most, the discretionary powers used in interim orders, ex parte orders. That concerns me quite a bit. We have seen people running to court last minute to get such far-reaching orders which are issued ex parte, and sometimes we don't even reflect on the ramifications of those orders. That is one area. I can't say it is being misused or abused, but given the effect, I think it's an area that ought to be looked at very, very carefully. Thank you, my lady.
Back to you, Chair.
Thank you very much, Acting CJ. Thank you, Judge. It is now the turn of Commissioner Judge Wasame to ask his questions.
Thank you, Professor. Judge, again, welcome. Judge, you have talked about how you have transformed the Court of Appeal. Now you will be head of the institution of the judiciary, and in particular, you will be the president of the Supreme Court. Tell us one thing you see as a problem in the Supreme Court you will solve within your first 60 days, if given the opportunity, God willing.
Thank you. It's a tricky one. I'm not in the Supreme Court. I'm not able to identify a problem. But going by the current discussions, going by the general feelings, of course, there have been many criticism of the court, whether right or wrong. I personally think that we have had very good jurisprudential guidance from that court. Just read judgments of the superior courts below the Supreme Court, and you will notice that we make reference to their decisions. But there are criticisms. All courts are criticized, including our court. I think the Supreme Court, having done 10 years, there ought to be some audit, some introspection. The equivalent in the UK, which was born 1 year before ours, had their reflection period, where you introspect, look at whether these criticisms are grounded or are just hot air. And that's all I can say, that perhaps it's time for us as a court to have self-evaluation and even involve scholars, to help us really break down these criticisms. Thank you, my Lord.
My Lord, again, the timelines provided under the Constitution, under the Elections Act, in terms of resolution of election petitions, is designed to facilitate quick resolution of the dispute. From the Magistracy, the High Court, the Court of Appeal, to the Supreme Court. Of course, I agree that there is timelines for Magistracy, High Court, and the Court of Appeal, the 6 months. But I have not seen any constitutional requirement other than Rule 28 of the Supreme Court rules. I have also read the strategic plan of the court 2020-2024. Of course, it has a catalog of fundamental landmarks, achievement which the court has done. But one thing that is missing is the timelines for resolution of election petitions. I have noted from my own research, sometimes they take 9 months, others take 8 months, others take 12 months. So how do you intend to resolve that problem and ensure compliance with Rule 28.1 that provides 90 days from the last day of the hearing?
Thank you, my Lord. Apart from the presidential one, the rest don't seem to have timelines, election petitions that end up there. But your question concerns rendering of a determination within 90 days. Long time we used to have judgment on notice. I'm saying long time because it's been discarded in most courts. If you give a date for judgment and 90 days pass, I think the rules require you to explain why the date, the ruling or judgment has not been delivered within that time. And so if you go beyond 90 days and there's no explanation, then that ruling or judgment becomes one on notice, which is something that ought to be discouraged if it is there. People come to court with grievances, things they cannot agree on, things that are dear to their hearts, and they want results either way. And so if you do not render a decision within those timelines, which were set deliberately for a purpose, then you have not rendered justice. A colleague in our court says it is like cooking. You can't be in the kitchen forever. People want to eat, bring food on the table. We bring judgments on the table. So I'm not answering that because I really don't know what is the situation in the Supreme Court. I'm just giving a general answer as to the 90 days.
Thank you very much, my Lord. And secondly, you have also talked about how, under your leadership, the issue of the backlog and ownership of decisions by the Court of Appeal has been very impressive. How do you intend to translate that record all across the judiciary?
Again, the concern has been in a collegiate court whether we need to write separate decisions. When you write separate decisions, you are thinking your philosophy is espoused. It is something provided, I believe, in most, or if not, perhaps all of our rules. And there's a reason why that is so. And so I would encourage people to write separately, but we face challenges when it comes to numbers. If you are each, like in our court, if you are each to write each time we had a matter, the time taken, you'd have done 2 others. And so, although the rules say as a general rule that separate decisions will be rendered, the reality is that it's not possible with our numbers. But it's an important thing to follow up.
Again, judicial officers all across the board have been accused of having inbuilt administrative nightmares and insensitivity to the citizens of this country. One area of concern to me is how sometimes we treat the elderly, terminally ill people and succession disputes. What is your idea of how to resolve or how to target those specialized litigants before court?
I'm told of an example of an old case at the Milimani Court of a paraplegic lady who has to be carried by people on the stairs up to the court. I'm aware we don't have ramps in most of the courts. I'm aware we have no braille facilities for those who are impaired in their sight. And there are so many categories of people who seek our services but are not able to get them. And if ourselves as judicial officers, judges, are not able to treat them when they appear before us with the respect, then that worsens their situation. So there are reports on how to deal with these categories. Even the task force I chaired had elaborate ways of dealing with that. The strategic plan that we have have ways of dealing with this. Really just to implement, to make sure that everybody who comes to court is catered for. Those who cannot hear, we have interpreters. Those who cannot speak the language of the court, we have interpreters.
Again, another area where we have been accused of being insensitive is that judicial officers keep files after the delivery of the judgment quite some time. Sometimes even inhibiting the right to appeal. What do you intend to do about that problem?
Very true. Perhaps not widespread. And the question is, once you deliver judgment, what is your interest with the file? That is a question of discipline. Because once you deliver judgment, time kicks in for many things. People want to apply for stay. People want to extract orders to execute. People want to appeal. So if you keep the file and there is evidence that you did that deliberately, it wasn't in the typing pool, that's a case for indiscipline.
Again, another problem is how to get fines and deposits refund from the judiciary. That's also another nightmare. How do you also intend to resolve that problem?
A nightmare indeed. When people come to court, you give a conditional stay, pay 2 million, and you get a stay, deposit in court. You come to court, you are fined, you are acquitted. Whatever deposit you place in court, that is your money. I'm aware in the past we used to have district treasuries. I'm not quite sure whether we still go there, but I'm also aware that almost up to 70 million shillings are tied in these district treasuries. And I'm aware too that there's a process to try and resolve that. Yes, but to answer your question directly, we must have a system, and I'm aware we are having JIFMIS that should be able to deal with issues of deposit instantaneously.
Another problem facing the judiciary also is the transfer policy for magistrates, judges, especially from the High Court. It is very effective in the Court of Appeal, as you know, but it is not followed for the High Court, the magistrate caddies and the staff. How do you intend to resolve that problem?
Transfers can also be described as nightmares. They disrupt families, they disrupt court work. It affects even litigants. And so when the judiciary leadership thought of having a framework, it was a great idea that people can plan. And as you have correctly, my Lord, noted, in the Court of Appeal, that is known. 2 years before you move to a next station. So your second year, the month of April, you start packing, and May you are in your new station. Nobody comes to say, I have a little child, I'm going to college. Nobody. It is something that has been accepted. The High Court and the other courts of equal status also have a policy. I know that policy has not been adhered to. I know magistrates and the judges who have been transferred within 6 months to so many stations, 2 or 3. There must be a way of institutionalizing this policy so that people know, people can plan. There's a financial aspect to it as well. If you move people, each time there's money paid as transfer allowance. The officers have to hire transport at the expense of the judiciary to move their household goods to the new stations. So there must be a firm policy that is known. Obviously, there are exigencies of duty. There may be a reason for a judge or a magistrate to be moved at once, but it cannot be very common.
Again, my lord, you talked about having, during your short time as the president of the Court of Appeal, you have given an identity to the Court of Appeal in terms of delayed judgments, in terms of ownership of the decisions, in terms of getting debts within the reasonable time. How do you intend to give courts like the Commercial Division, which is sometimes unfairly accused of having lost its identity, the Labor Court, which is sometimes unfairly accused of being pro-employees court, the Land Court, which is also sometimes unfairly accused that it is nightmare to get a hearing date from that court. How do you want to give those three divisions or three courts an identity?
Yes, the accusations are there. I've heard them. But we must understand the background why we have these accusations. It really boils down to numbers, judges. So when you hear that your matter that you filed in 2020 will not be heard until 2025, then you know something is wrong. So to begin with, the identity that they must be given is expeditious disposal, which they can only achieve if they have the numbers. They can also get that identity by being active in case management of the cases that are before them, to be able to identify which cases have been there long, and to identify those cases that are urgent in nature. But the whole thing boils down to capacity. Thank you.
And lastly, another nightmare facing the judiciary or the administration of justice, my lord, is the Meru case. The Supreme Court, respectively in my view, dealt with the circumstances, the degree, gravity, and the culpability and the exceptional nature of the death penalty in terms of Section 203 as read with 204. And what the court said, from my reading, I could be wrong, is that the two accused persons, and the court, let me start by saying, this decision, the court was very specific and said it only applies to these two petitioners, Meru and Mangi. Again, the court did not set aside the death penalty, which was imposed by the High Court and also upheld by the Court of Appeal. But they remitted back the matter to the High Court for resentencing. And what the court was saying, in my view, is that a formal equal penalty for an equally wicked crimes and criminals is not in keeping with the tenets of a fair trial. And the court said, anybody who thinks there is a problem of the death penalty need not to approach us, but go to the relevant court, and then they come to us. And they said, the AG to set up a framework to deal with the sentence and rehearing of cases relating to the mandatory nature of the death sentence. Of course, the point I'm raising, my lord, is that there has been a remarkable concerns that that judgment has been misused and abused and misunderstood and misinterpreted by all the courts, from the Court of Appeal to the Magistrate Court. And now it's free for all. How do you intend to resolve that nightmare as CJ Ouko?
Thank you, my lord. On a light note, I think Kenyans must be wondering this Meru and Nakuru man that is being discussed in this tent from the time we started. perhaps the Commission may want to introduce him at the end of your exercise. He's a great guy. He very resilient. He brought a change to our jurisprudence. Muruatetu, a very resilient man. Having said that, perhaps we go back to the decision of the Court of Appeal just a month before the promulgation of the Constitution, the Ngothom Mutiso, where the court was faced again with the 204 crime, section 204. And the court was very specific. The court said this decision is limited to this case and to the mandatory nature of death sentence under section 204. And it went on to say that it perhaps may apply to the other capital offenses, and they named them: treason, robbery with violence, attempted robbery with violence. They said a day will come when that will be resolved. But for now, Ngotho's case ends with the determination that death penalty is not the only punishment that you can be given when you commit murder. Then, of course, came a 5-judge bench of the Court of Appeal a few years later in the case of Joseph Mwaura, and the same question arose, except I think Joseph Mwaura was robbery with violence, but the principle of the mandatory nature of the death sentence was still at the center of it. And the court said, we have no alternative. The law says you murder, you commit robbery with violence, it is death, nothing less. Then the Supreme Court came. The Supreme Court agreed with the first case, Ngotho, and said what it said. The two issues that I think have been raised, that after that decision, there's been confusion. I think the courts and the practitioners ran to town. The Supreme Court had said, hold, they had actually said what Ngotho said, that this case relates to the circumstances of this case. But the Supreme Court, in my view, said two things that perhaps has caused the confusion. The first is, I think, paragraph 48, which I think people have misread. Paragraph 48 of that decision, the court says that you cannot take away discretionary powers of a court in sentencing by an act of parliament, that is not the role of the legislature. Of course, they've gone on to explain again that it was really in relation to what they were saying. Personally, I don't think they were saying it generally. Then they asked the Honorable the Attorney General to come up with a framework, what they call structural interdicts. And I think perhaps people waited and became impatient. There was no direction, and we took the law in our own hands, hence the confusion. I can't blame the Supreme Court. Had we held our hands, had we waited for the framework, perhaps this confusion would not have been there. So what I'll do, if you allow me to be the Chief Justice, because the Supreme Court did not finish its work. It gave an interdict. Have a mention and hear what the Honorable the AG has to say with regard to the assignment that he was given now nearly 3 years, and you make a decision from there. Thank you, my lord.
Thank you, my lord. I wish you well. Thank you, Professor.
Thank you, my lord.
Thank you, Judge Wasame. Thank you, Your Honor. I think we have now questions from Commissioner Judge Majaja before we take a break. Commissioner.
Thank you, Chair. Good morning once again, my lord.
Good morning, sir.
One of the tasks I've been given is to deal with your writings, not necessarily to interrogate the reasons, but just to satisfy the Commission that you meet the standard, and I must say that they are very impressive. We have 4 judgments. The first one is in a civil appeal, Kenya Hotel Limited and Oriental Commercial Bank. Another one in Elizabeth Wambui Githinji versus Kenya Urban Roads, and a ruling in Judicial Service Commission versus Honorable Lady Justice Kalpana Rawal. What I read from those decisions, first of all, they are individual judgments. In 2 of them, you actually delivered the majority decision, and there were dissenting decisions. I think one of the issues I had raised with your colleague, and probably you followed that debate, and you've mentioned it, is the level of accountability for individual judges in the Court of Appeal or in a collegiate court to the public, being able to write your own decision. And my view and assessment, and correct me if I'm wrong, over the period, the Court of Appeal has not done very well. You've been writing joint judgments, and when I look at other courts of your status, Supreme Court of Appeal South Africa, there are 5 judges, but normally, even when they agree, it is one judge who writes and he's identified. Look at Tanzania, look at Ghana, that's what happened. So maybe you want to tell the public why this is a different position. And in fact, if you look at the old East Africa Court of Appeal, that was also the position. That's why we know Madan, that's why we know Dibold J said X, Y, Z. Why is that?
Yeah, thank you, my lord. Yes, it is very important to not have known Nyarangi was a great judge, but his decision, one decision that has stood the test of time, the Lillian S, has his name on it. And so I can't overemphasize the need for a collegiate court to have separate opinions. It is in our court, there are those who think we should be doing separate judgments, but there are those who think that the reality is that the numbers cannot allow us to do that, because if you hear one matter and each one of you has to write a reasoned judgment, the time you take to do that in one case, you'd have done 2 others. So that's one reason, not a very persuasive reason, but it's based on the current number of judges. And we had actually resolved that when we get the 11 judges, that is going to be the way, because it is provided for in our rules as a general rule that to begin with we must write single judgments. And so I want to admit to the public that that's one area that we haven't done very well on account of our capacity.
Because, and I agree with you, it's not a very good reason, because it is one judge who writes. Once you agree, you conference, you say, Judge so-and-so right, and the rest just concur. So it doesn't add, unless the case is of such magnitude that you feel that you need to write single judgments. It's normally you agree as a panel, and then one judge writes and the rest concur, and that's what I've seen in the other jurisdiction. But let me go to the next question, and this is a quote from a young jurist called Walter Kobe on the Court of Appeal. It's a quote, it's out there, and it says as follows in the platform. If there's a group of people whose ideology is contrary to the spirit, values, and principles of the 2010 Constitution, It is the judges of the Court of Appeal. In fact, there's a group of people who are irredeemably mired in a legal culture of liberal legalism, that is formalism, positivism, rule-bound technical approach to adjudication associated with the pre-2010 dispensation, and are oblivious to the demands of change in legal culture demanded by the 2010 Constitution. It is the judges of the Court of Appeal. So this is criticism. So, as the president of this court, is this statement true? And probably you would give me examples or give the public examples why you think this statement is not true or correct, as you may.
I'm actually surprised. We thought we were doing our best. We thought we were progressive. And so I do not know where Mr. Kobe did his research, if he's able to identify decisions that he thinks are not progressive, because that's what we encourage. Even among ourselves, we sometimes reflect on our decisions where we have gone two different ways. And we have invited people to come and talk to us from the academia, from the legal practice in the court, in order to be able to have this robust jurisprudence that we talk about in the judiciary. So really...
So can you give us an example of what you consider progressive jurisprudence from the Court of Appeal?
There are many, my lord. There are very many.
Because you have to answer this question, so give us 2 examples.
We have made decisions in election petitions that have gone to the Supreme Court and upheld, and so many other decisions. This Muruatetu and all these things we are discussing all pass through the Court of Appeal. So I think it is unfair criticism without detail. And so it's to answer...
So for example, he says Mitubel, one of the decisions he discusses, the decision of Mitubel.
Right.
Of course, Mitubel has now been overturned by
Supreme Court.
The Supreme Court. He also mentions this decision which you quoted, this one of the decisions in your this position in Elizabeth Wambui, the one you gave the majority decision. Another one, for example.
Mitubel, yeah, so it's good when somebody criticizes and gives you an example, then you are able to respond. Of course, the Mitubel, the main reason was the way the Court of Appeal did not reflect on the issue of structural interdict. I think that may be a valid criticism. Okay. I want to admit. I don't know what the problem with Wambui case was.
This is, in fact,
the Runda?
Yes, the Runda case,
right.
About illegally acquired land.
Yes.
And in that respect, I think there have been several decisions that are conflicting on how the courts should deal with the illegally acquired land from the Court of Appeal, and that has actually caused a lot of concern in the lower courts. The Court of Appeal has given conflicting views on that particular issue.
Yes, I can talk about the Runda one. It is more or less Mitubel, if you asked me, except maybe for the area where these people are. They are in Runda. Mitubel was Mitumba village. But save for that, if I sat in Mitubel, I would have done the same as I did in the Runda case, because these are people who settled on that land from the 70s. The road on which they say to have encroached was built, and cars drive through it. The surveyor, government surveyor, confirmed that that stretch of the road, the width was 60 and not 80 meters. And what was going to happen to nearly 300 families was to have their homes demolished. Some homes were 35 million. That's not really a big consideration, but the fact that they had titles issued by the government, the fact that the survey was done by government surveyors. So I would say that if I sat in Mutubel, I would have come to the same conclusion like the Runda decision.
In Mutubel, the court seemed to cast doubt on prescriptive rights. If you read the decision, they seemed to suggest that prescriptive rights are not permitted. You are aware of that?
Yes.
Yes. But then in a very decisive case in Malindi, when you were sitting at Malindi, now in fact this is a case where the 3 judges gave very considered opinion on the constitutionality of adverse possession. You recall Mtana Lewa?
Yes.
Very detailed, and you rebuffed any suggestion that prescriptive rights over land are unconstitutional.
Yes.
So, do you think it's right for the Supreme Court to cast doubt on prescriptive rights, particularly when that was not an issue before them?
That's a tricky one also, because Article 163, I'm bound by their decision, and I can't say that they were wrong. I can only say that we decided Mtana Lewa on the matter that was before us, the question being, is adverse possession unconstitutional? And we said it is not, because there are procedures to be followed, there are conditions to be satisfied before you get title under adverse possession. The possession is not arbitrary. That's what we decided in Malindi.
My position is really, and the question I'm asking this is because you'll be sitting in that court, and just as we have been discussing, the obligation of the court is to be careful about what they talk about, isn't it? They're very circumspect. And by the way, probably that is why the Court of Appeal is always condemned sometimes, because you actually sometimes take a narrow view of the issues you have. So in Mitubel, the issue was squatters on public land. But the court went ahead and suggested, and that's why I'm asking you whether that's a correct assertion by an apex court. It suggested. So you sitting as an appellate court, would you approach that issue in that way?
One thing I was taught when I joined the bench as a judge, having been in administration for so long, those old Court of Appeal judges told me that decide a matter on the basis of what is before you. You may have great ideas you want to put in a matter, wait until the occasion presents itself. And so you're right that we are very, very circumspect when it comes to the matters that we deal with. If you think that you do not want to be bound by a statement that was made, what colloquially would be called out of context or in per curiam, then you go for the main decision that the court made, and you do not have to follow what was not before the court.
And now this brings me back to Muruatetu, because again, it goes to the same way decisions are made. So you have told us, and again, correct me if I'm wrong, the issue in Muruatetu concerned Muruatetu, this man whom we talk about but we don't know. He has been sentenced to death. All the court was saying is that the mandatory death sentence, just as the court held in Mutiso's case. The same thing, but that was pre 2010. This is after 2010, reaching the same conclusion that death sentence is not mandatory, or the mandatory nature of the death sentence is unconstitutional. What did your court, and again I'm saying this because it's your court, say about Muruatetu in respect of sexual offenses?
Yes, again, we just borrowed paragraph 48, that we have been given guidance by the Supreme Court in the sentence where they said discretionary powers cannot be taken away by a statute. And so we ran to town. We are now applying it in sexual offenses. And I believe there are other offenses where perhaps other courts are applying it, where we have minimum sentences. As I say, it is not neat because of the confusion it has brought to the judicial system.
So the court is, basically what the court in Muruatetu was saying is the legislature cannot take away judicial discretion, cannot take away the judicial function and arrogate it to itself. That was the principle. So what is wrong with a court anywhere sitting saying, the court, forget about the offense, what is wrong with a court sitting anywhere saying that this is what the Supreme Court has said? There is nothing wrong. Is there anything wrong? Because that is basically the decision, that is the foundation of the decision.
Yes, and I said we had a similar decision in 2019. No, it was July 2020, the Mutiso. But people didn't run to town. We did not interpret it to mean, and they said the same thing about discretionary power. So I think as a general rule, really, that's the law, that the powers of the court cannot be taken away when it comes to issues of sentencing. But it's the way it is being done now, that appellants from the Court of Appeal go back to the magistrates' courts, irrespective of the offenses, and they're having those sentences reviewed.
So who can you blame? No, let me not ask that. So actually, the fact is, Supreme Court met. So who are you blaming for that particular mess? Who are you blaming? Because people are entitled to go to court anywhere.
I don't want to blame anybody. I want us to get a solution to the problem.
Okay. Now, there is another case, again, which this case of Kalpana Rawal and others, JSC versus Kalpana Rawal. And again, it's one of the decisions you gave, and this was a 5-judge bench. All the judges gave separate decisions, I believe because of the magnitude and importance of the decision regarding the right of appeal. The Supreme Court has now come up with another right of appeal, and I take this from my colleague, restlessness of jurisdiction. What is called restlessness. And I call it residual jurisdiction, coming from Newton and the cases. So what is this residual jurisdiction?
In relation to Newton?
In relation, actually, let me take, in this case, you are very clear, and this is what I always understood, that a right of appeal can only be conferred by the Constitution or the law.
Yes.
That's what the court was saying here. And in light of Section 163, right of appeal to Supreme Court on constitutional issues, it meant that, in fact, there was a right of appeal to the Court of Appeal. Am I right?
You're right.
That was the law. But there is another residual jurisdiction that has come up that says, and this is says, if there is an error so grave, the court must be able to intervene. That is the new to jurisprudence. Are we on the same line?
Yes.
Yes. So what is the problem with that kind of decision? What do you see going ahead where you sit? We've already talked about the problems in Muruatetu, in the other cases. Now let us look at this residual jurisdiction problem.
Lord, I think I said at the beginning that there are many issues being raised about decisions of the Supreme Court. And I said also that the Supreme Court has been giving us, in many cases, the ones that they're being criticized are isolated. By and large, we've been getting guidance from the Supreme Court. Hamana's Koinange investment defines the jurisdiction of the Supreme Court. And now, from what people are saying, there seems to be some mix-up, that the door seems to be opening. Yet in the Koinange investment, the Supreme Court said that there's a sieving mechanism, just the way you sieve tea. Tea leaves remain in the sieve, and only pure tea goes into the cup. That this mechanism ought to be strictly followed. But again, there's been talk that the door is opening wide and wide. And that brings me to what I said earlier, a time for us as a court to take all these things with our stride, sit together as judges, get all these areas where we are being accused, wrongly or rightly, that we have overreached. Let us reflect. Let us get scholars to look at these areas that you are identifying and tell us, this is the road, you have left the track. It is only through that courts grow. And for me, it is all very well. If you criticize the court where I work, just show me the instances and we will look at it. It makes us wake up that there are people there who are watching us. The Supreme Court is so important to this nation that we must, as judges in that court, take these criticisms seriously, because institutions are run down when they bury their heads in the sand. We need to take criticisms positively and address them.
Okay. There is a case, one of the major cases you'll be dealing with are election petitions. You are aware of the decision in Martha Karua. You know the history of the Martha Karua case from the High Court, Court of Appeal, Supreme Court, High Court again. You know the history.
Yes,
you also know that it went to the East Africa Court of Justice. And the East Africa Court of Justice said something. It awarded Honorable Martha Karua damages for infraction of the Constitution. One of the commentators, again, I like reading criticism or comments, is called Caxton Higata. He calls this a legal brawl between the East Africa Court and the Supreme Court. As a Chief Justice and President of that court, is this something that would concern you, that people have to go outside the country for relief against what the Supreme Court itself has done, and how would you propose to deal with that kind of situation?
The timelines of election disputes. I sat in the initial one, in the Martha Karua one. We had hardly 4 days to the end of 6 months, I think so. In fact, I sat with my brother, Commissioner Warsame, and Judge Musinga, and we debated, is it worth taking back when they have 4 days? Where is time to be able to call evidence? But we said that is for that court to decide. We do our bit and send it back. And so it has rolled across the borders of this country and back. So again, without casting any aspersions, again, really just to review all these things. If it's the law, we are able to recommend what laws need to be amended or made. But the beginning is to reflect.
So what is your reflection on this particular case?
Reflection will have to be collective.
No. Now you're the Chief Justice, you're concerned because it would undermine the position of the Supreme Court if every litigant kept, when they leave your court, they go to East Africa Court and they are awarded damages. You can imagine what that does to the credibility of your court. So there must be something you can think about, and you tell us that when I'm Chief Justice, this is what I would do.
Obviously, the credibility of the court suffers when people have to leave Kenya to go and seek redress outside Kenya. I really do not want to say more than I've said regarding the Supreme Court and what I will do when I get there, if you give me the chance, will to ensure that this does not happen, because we will have collectively to agree on how to deal with this situation.
Okay. Now, there is a doctrine called the political question doctrine in terms of constitutional adjudication. Can you just briefly explain to us what it means and where it finds its place in the Constitution, if it does, and where it finds its place? The political question doctrine.
Sorry to ask, is it something to do with justiciability?
Yes, sometimes referred to as justiciability or the political question. The court saying, this is a political question, we will not deal with it.
Right.
So does it find its place in the Constitution, or what is the basis for the court saying that this is a political question?
I can't right away think of the provision in the Constitution, but there are disputes that are better resolved through political mechanisms. I know long time there would be issues of nominations by political parties, violations of rules and constitutions of political parties that the courts would be very reluctant to address. So I can't recall exactly what provision it is at the moment.
So is it an issue of, again, on the same point, is it an issue of jurisdiction, or is it an issue of avoidance?
I think it is avoidance, because avoidance is to avoid flogging the Constitution too much. To avoid is to return certain matters to where they belong. And so I think this is one of those instances where avoidance can be used.
Okay. My last question, which we've asked all candidates. The court which you preside is the one, I believe, that has suffered most because of the 11 judges. In fact, one of your key, what I would say, limiting factors to your success. You have been successful, and for example, you have 67%, satisfaction amongst the public. But what is holding you back is those 11 judges, isn't it?
Yes.
Chief Justice Ouko, what is your solution to that issue?
Very true. My court has actually felt the brunt of this. When I joined the court, we were when I joined the court, we were 27. Shy, the 3 judges shy to the complement under the Constitution. 27. And work was smooth. We didn't have to sit the way we are sitting now. And with time, this number has been dwindling. Judges have retired, a judge has died, and so we are 15. 15, if you take away myself, if you take away my Lord, Commissioner Warsame, if you take away the Director, Mr. Justice Ntoinoti at JTI, you have 12. That's a court that we sit 3. So 12 would translate to 4 judges. 4 judges dealing with appeals from nearly 200 judges from the courts below. And so we felt the weight because of this. And so when I talk about what we've gone through, it is really from my heart. There ought to be a way out. And for me, if you graciously give me the opportunity, I'll come back to you. I'll come back to the commission. This is where it all started. To retrace our steps, to find out where the rain started beating us, to find out, as it is now, I can't tell exactly where the stalemate is, but I know there are cases. I don't know the nature of those cases, apart from what we read in the papers. So I'll come back to the commission. And depending on what I get from the commission, and depending on what the commission thinks, of course, I personally, I'll have my own view that the solution lies with the head of state, and that's where we will take our grievance. I believe that as head of a branch of the government, as head of the judiciary, a chief justice has some structured channel of communication with the head of state. And if there is none, it will be really for me to establish that structure, channel of communication, which will involve all the 3 branches of government, because that's how governments work. A government has 3 legs like an African traditional stool. So those legs are the same. And if one is short, then you can't comfortably sit on that stool. So the eventual protocol will be at State House.
That is all, Chair. Thank you, and thank you, my Lord.
Thank you.
Thank you very much, Honorable Judge Majaja. Thank you, Your Honor. We'll now take a short break, 10 minutes, and we'll be back at 11:30. Thank you.
Thank you, Chair.
Raukia siku njema na tunukiwa offers kila siku. Pata offers zote mahali pamoja ili uongee zaidi, utume SMS zaidi na ubrowse zaidi.
Wewe usijali. Tuma namba ya kila supplier kwa hiyo soko. Nitajua nitaongea na kila mmoja wao.
Very good. Piga *444 hash utunukiwe Credo Double.
Raukia siku njema na tunukiwa offers kila siku.
Oh, hi. It's not what you're thinking. It's a cup of coffee. Coffee, movie. Together, coffee with movie. Every Sunday, 8 p.m. on TV 47, where we bring you interesting, enticing people. Well, we've concentrated on musicians.
Yeah. Yeah.
Producers.
So now I manage because telemanagement and events management, I think, was my passion.
Right about now, we want to go beyond to the counties and to other countries. Out here, let the sun stand still like Joshua time for 3 hours, but this time for only 1 hour. We bring you coffee with movie, interesting, enticing guests. Out here, tunaanza tuna Mombasa, Kisumu, Nakuru, twende Uganda, Magufuli Land, TZ. You never know. It is coffee with movie. Jua unaweza enda sasa.
Okello.
Before the markets open, farmers begin their day, each with the desire to produce the best. But how can they increase the numbers, maintain the standards,
Aitoi ile garlic inafaa itoi, that standard garlic.
reduce the cost,
we spread our risk,
and yet remain the best? Kilimo Diaries, every Sunday when the clock hits 7:30 p.m. The story continues to unfold. The race to win Abel's heart continues.
Huyo mwanamke ataniona, Abel is my mwanamke mgani, ni nani huyo na nini mbaya?
The betrayal.
Manze chinja huwa hakuna blanda sasa ni huyo madam pale hivi sasa.
And the secrets.
Jenny, si nikwambia napenda Abel. Nampenda tena sana. Nashindwa venye nitaanza. Lakini nashindwa nitaanza aje.
Usichekeshe.
Plan ya siri every Saturday at 8 p.m. Did you know that your business keeps our economy running?
You need the skill, not the papers.
Always tell yourselves, one day at a time. You can't do everything.
Owning a home is a keystone to wealth. And building one can be quite daunting. Well, the realtor gives you the do's and don'ts.
There are so many brokers in the market who just want to tell you I can be able to supply.
And groundbreaking.
So we clear the area and we set out the place where the house is going to be laid down.
We talk homes, land and property.
With me, Karanzi Daniel.
Every Tuesday at 7:30 p.m. How well do you know what's happening around you? Morning Cafe with heated political debates.
The position of the Prime Minister will go to a party with the most elected members.
I clearly know that neither Raila nor Ruto are in the work plan on the roadmap for transition as far as the government is concerned.
Informative health discussions, business, farming, Tasty Wednesday, Fitness Thursday, and Feel Good Friday with amazing DJs, celebs, and music bands.
Back to the seasons of my youth.
Every Monday to Friday from 6 a.m.
Raukia siku njema na tunukiwa offers kila siku. Pata offers zote mahali pamoja ili uongee zaidi, utume SMS zaidi na ubrowse zaidi.
Wewe usijali. Tuma namba ya kila supplier kwa hiyo soko. Inter-governmental itaongea na kila mmoja wao.
Very good. Piga *444 hash utunukiwe Credo double.
Raukia siku njema na tunukiwa offers kila siku.
You are what?
Oh, hi. It's not what you're thinking. It's a cup of coffee. Coffee, movie. Together, coffee with movie. Every Sunday, 8 p.m. on TV 47. Where we bring you 80,000 enticing people. Well, we've concentrated on musicians.
Yeah.
Producers.
So now I manage because telemanagement and events management I think was my passion.
Right about now, we want to go beyond to the counties and to other countries. Ouko, let the sun stand still like Joshua times for 3 hours, but this time for only 1 hour. We bring you coffee with movie, interesting, enticing guests. Ouko, tunaweza anza tuna Mombasa, Kisumu, Nakuru, twende Uganda, Magufuli Land, TZ, you never know. It is coffee with movie. Jua unaweza enda sasa.
Okello.
Before the markets open, farmers begin their day, each with a desire to produce the best. But how can they increase the numbers, maintain the standards,
Aitoi ile garlic inafaa itoi, that standard garlic.
reduce the cost,
We spread our risk.
and yet remain the best? Kilimo Diaries, every Sunday when the clock hits 7:30 p.m. The story continues to unfold. The race to win Abel's heart continues.
Huyo mwanamke ataniona. Abel is my mwanamke mgani ni nani huyo na nini mbaya?
The betrayal.
Manze chinja huwa hakuna blanda. Sasa ndio yule madam pale hivi. Sasa
And the secrets.
Jenny, si nikwambia napenda Abel. Nampenda tena sana. Lakini nashindwa venye nitaanza. Lakini nashindwa nitaanza aje.
Usichekeshe.
Plan your siri every Saturday at 8 p.m. Did you know that your business keeps our economy running?
You need the skill, not the papers.
Always tell yourselves, one day at a time. You can't do everything under one roof.
Over time, I've had to realize that good things take time.
The Grind, every Monday at 7:30 p.m. As the country gears up for possible BBI referendum and 2022 general elections,
as the salvos enter too familiar territory,
William Ruto will serve his 5 years term as the deputy president.
Pundits Night is here to give you powerful, thought-provoking political commentaries.
The mountain can produce a country.
Give Moses Kuria a chance to respond. Let me ask you this. Are you not taking advantage of first my situation?
You talk about the people with the ultimate power.
Kikuyus will vote for somebody from outside their community to be the next president of this country.
We talk to the newsmakers, the opinion shapers, and the pundits.
Fair enough. I believe
that part so that I don't
as we dissect everything you need to know to make an informed decision. Owning a home is a keystone to wealth. And building one can be quite daunting. Well, the realtor gives you the do's and don'ts.
There are so many brokers in the market who just want to tell you I can be able to supply.
And groundbreaking.
So we clear the area and we set out the place where the house is going to be laid down.
We talk homes, land, and property.
With me, currently Daniel.
Every Tuesday at 7:30 p.m. How well do you know what's happening around you? Morning Cafe with heated political debates.
The position of the Prime Minister will go to a party with the most elected members.
I clearly know that neither Raila nor Ruto are in the work plan on the roadmap for transition as far as the government is concerned.
Informative health discussions, business, farming, Tasty Wednesday, Fitness Thursday, and Feel Good Friday with amazing DJs, celebs, and music bands.
Back to the seasons of my youth.
Every Monday to Friday from 6 a.m.
Raukia siku njema na tunukiwa offers kila siku. Pata offers zote mahali pamoja ili uongee zaidi, utume SMS zaidi na ubrowse zaidi.
Wewe usijali. Tuma namba ya kila supplier kwa hiyo soko. Inter-governmental ongea na kila mmoja wao.
Very good. Piga *444 hash utunukiwe Credo double.
Raukia siku njema na tunukiwa offers kila siku.
Oh, hi. It's not what you're thinking. It's a cup of coffee. Coffee, movie. Together, coffee with movie. Every Sunday, 8 p.m. on TV 47, where we bring you interesting, enticing people. Well, we've concentrated on musicians.
Yeah.
Yeah.
Producers.
So now I manage because telemanagement and events management I think was my passion.
Right about now, we want to go beyond to the counties and to other countries. Ausio, let the sun stand still like Joshua time for 3 hours, but this time for only 1 hour. We bring you coffee with movie, interesting, enticing guests. Ausio, tunaweza anza tuna Mombasa, Kisumu, Nakuru, twende Uganda, Magufuli Land, TZ, you never know. It is coffee with movie. Jua unaweza enda sasa.
Okello. Before the markets open, farmers begin their day, each with the desire to produce the best. But how can they increase the numbers, maintain the standards,
Aitoi ile garlic inafaa itoi, that standard garlic.
reduce the cost,
We spread our risk.
and yet remain the best? Kilimo Diaries, every Sunday when the clock hits 7:30 p.m. The story continues to unfold. The race to win Abel's heart continues.
Huyo mwanamke ataniona. Abel is my mwanamke mgani ni nani huyo na nini mbaya?
The betrayal.
Manze chinja huwa hakuna blanda sasa ndio huyo madam pale hivi sasa.
And the secrets.
Jenny, si nikwambia napenda Abel. Nampenda tena sana. Lakini nashindwa venye nitaanza. Lakini nashindwa nitaanza aje. Usichekeshe.
Plan your siri every Saturday at 8 p.m. Did you know that your business keeps our economy running?
You need the skill, not the papers.
Always tell yourselves, one day at a time. You can't do everything under one roof.
Over time, I've had to realize that good things take time.
The Grind, every Monday at 7:30 p.m. As the country gears up for possible BBI referendum and 2022 general elections,
As the salvos enter too familiar territory,
William Ruto will serve his 5-year term as the deputy president.
Pundits Night is here to give you powerful, thought-provoking political commentaries.
The mountain can produce a country.
give Moses Kuria a chance to respond. Let me ask you this. Are you not taking advantage of first my situation?
You talk about the people with the ultimate power.
Kikuyus will vote for somebody from outside their community to be the next president of this country.
We talk to the newsmakers, the opinion shapers, and the pundits.
Fair enough. I believe
that part so that I
General
don't
Gay-
As we dissect everything you need to know to make an informed decision. Owning a home is a keystone to wealth. And building one can be quite daunting. Well, the realtor gives you the do's and don'ts.
Some so many brokers in the market who just want to tell you I can be able to supply.
And groundbreaking.
So we clear the area and we set out the place where the house is going to be laid down.
We talk homes, land, and property.
With me, currently Daniel.
Every Tuesday at 7:30 p.m. How well do you know what's happening around you? Morning Cafe with heated political debates.
The position of the Prime Minister will go to a party with the most elected members.
I clearly know that neither Raila nor Ruto are in the work plan on the roadmap for transition as far as the government is concerned.
Informative health discussions, business, farming, Tasty Wednesday, Fitness Thursday, and Feel Good Friday with amazing DJs, celebs, and music bands.
Back to the seasons of my youth.
Every Monday to Friday from 6 a.m.
Safari anza ya kutuunganisha kama Wakenya. Twende tukiuke, let's go beyond, let's go beyond, let's go beyond. Mimi nawe
Raukia siku njema na tunukiwa offers kila siku. Pata offers zote mahali pamoja ili uongeze zaidi, utume SMS zaidi na ubrowse zaidi.
Wewe usijali. Tuma namba ya kila supplier kwa hiyo soko. Nitajua nitaongea na kila mmoja wao.
Very good. Piga *444 hash utunukiwe Credo double.
Raukia siku njema na tunukiwa offers kila siku.
Oh, hi. It's not what you're thinking. It's a cup of coffee. Coffee, movie. Together, coffee with movie. Every Sunday, 8 p.m. on TV 47, where we bring you interesting, enticing people. Well, we've concentrated on musicians.
Yeah. Yeah.
Producers.
So now I manage, because telemanagement and events management, I think was my passion.
Right about now, we want to go beyond to the counties and to other countries. Out here, let the sun stand still like Joshua time for 3 hours, but this time for only 1 hour. We bring you coffee with movie, interesting, enticing guests. Out here, tunaweza anza tuna Mombasa, Kisumu, Nakuru, twende Uganda, Magufuli Land, TZ, you never know. It is coffee with movie. Jua unaweza enda sasa.
Okello.
Before the markets open, farmers begin their day, each with the desire to produce the best. But how can they increase the numbers, maintain the standards,
Aitoi ile garlic inafaa itoi, that standard garlic.
reduce the cost,
We spread our risk.
and yet remain the best? Kilimo Diaries, every Sunday when the clock hits 7:30 p.m. The story continues to unfold. The race to win Abel's heart continues.
Huyo mwanamke ataniona. Abel is my mwanamke mgani ni nani huyo na nini mbaya?
The betrayal.
Manze chinja huwa hakuna blanda. Sasa ndio huyu yule madam pale hivi. Sasa
And the secrets.
Jenny, si nikwambia napenda Abel. Nampenda tena sana. Nashindwa venye nitaanza. Lakini nashindwa nitaanza aje.
Usichekeshe.
Plan your Siri every Saturday at 8 p.m. Did you know that your business keeps our economy running?
You need the skill, not the papers.
Always tell yourselves, one day at a time. You can't do everything under one roof.
Over time, I've had to realize that good things take time.
The Grind, every Monday at 7:30 p.m. As the country gears up for possible BBI referendum and 2022 general elections,
As the salvos enter too familiar territory,
William Ruto will serve his 5-year term as the deputy president.
Pundits Night is here to give you powerful, thought-provoking political commentaries.
The mountain can produce a country.
they give Moses Kuria a chance to respond. Let me ask you this. Are you not taking advantage of first my situation?
You talk about the people with the ultimate power.
Kikuyus will vote for somebody from outside their community to be the next president of this country.
We talk to the newsmakers, the opinion shapers, and the pundits.
Fair enough. I believe
that part so that I don't lose.
As we dissect everything you need to know to make an informed decision. Owning a home is a keystone to wealth. And building one can be quite daunting. Well, the Realtor gives you the do's and don'ts.
So many brokers in the market who just want to tell you I can be able to supply.
And groundbreaking.
So we clear the area and we set out the place where the house is going to be laid down.
We talk homes, land, and property.
With me, Currency Daniel.
Every Tuesday at 7:30 p.m. How well do you know what's happening around you? Morning Cafe with heated political debates.
The position of the Prime Minister will go to a party with the most elected members.
I clearly know that neither Raila nor Ruto are in the work plan on the roadmap for transition as far as the government is concerned.
Informative health discussions, business, farming. Tasty Wednesday, fitness
You
Thursday.
presented, which I confirm okay, that this is the decision relating to Mwangi Stephen Murithi and the former president Daniel Toroitich arap Moi. You are a 3-judge bench, and you may correct me if I'm wrong. Now, what I noted is that Mwangi Murithi was claiming that he had been unlawfully detained by the former president with the sole purpose of taking his properties. He claimed that he owned some shares in a corner house, in a Rupani house, Atlas House, and several other buildings, Kenwood and all that. And the High Court, this Justice Gacheche, found in his favor, and proceeded to award, millions of shillings to him, declaring that the detention itself was unlawful and not for protection of national security, but for purposes of depriving him of his properties. I'm referring to this case because I remember when I was much younger, I used to see, in the newspapers a lot about this man who was in I think he was special branch on intelligence, I can't remember, who was suing the president because of this, detention that he thought was illegal. Now, when the matter went to the Court of Appeal, what I noted is that in the High Court, the former president never put any responses. He never, in as much as it was affidavits, but there was no affidavit in response, controverting what Mwangi Murithi was indicating. In fact, what I think was put was just a preliminary objection by counsel for the former president, now deceased. And the Court of Appeal now went ahead, notwithstanding that there was no evidence to controvert what Mwangi Murithi was saying. The Court of Appeal still went ahead and set aside, that judgment, and they filed in favor of the president, who had never filed any evidence, no affidavit, in as much as, of course, there was no viva voce evidence and all that. So I didn't understand the rationale behind it, because I thought that it was too drastic to shut him out. This is now for me, of course, you are the judges. I'm not saying I'm right. I just want to understand the jurisprudence. And I even found that apart from setting aside that judgment, he was even condemned to pay costs. This guy who has gone through all this suffering, the detention, and you can remember during those early days when these drastic laws were being applied against Kenyans. And then not only is his judgment set aside, which of course you have a right to set it aside, for good reason, but even also condemning him to pay costs. I don't know if you could just explain what could have informed that jurisprudence. Not to fault what the judge said, but I just want to understand what was the rationale behind it.
Thank you, Commissioner. Excuse me. It's been a while. I can't remember very clearly the decision. And I think in future, just as a recommendation, to avoid what lawyers call ambush, to provide some of these, if particularly there are cases we've dealt with, to provide in advance so that we are able to respond effectively. As it is now, I'm not completely able to give reasons why we, because it's really a matter that was decided many years ago. But I know we were wondering why, in that case, why was the AG not sued? Then we were also wondering, in the law, the president at the time, I do not think, if I recall well, had personal powers to do what he was being accused of doing. There was, I think, a committee that would do this, some security committee. And we thought that the respondent before us had not proved that he owned these properties, because I don't think that he had produced documentary evidence to show that they were in partnership or they had companies jointly with the late president. So just really from the top of my head, that would be my answer, that without me having gone through, it will be difficult, but we thought the learned judge of the High Court erred in awarding costs that were not proved and awarding liability that was also not shown.
Yeah, actually you're right, you've captured it. The way you've just said, that's also a decision now by the judge. It's a 2014 decision. Now I think, what the court said is that notwithstanding the affidavit and all that, there was not enough documentary evidence. My only question was that at least the petitioner had provided his side of the story with what his affidavits and what he thought was the documents, but there was no there was no evidence on the other side controverting that. In fact, the Court of Appeal said that at the very least what the judge should have done is probably even to consider taking the matter for formal proof, to now prove the way you are saying. So, which now left me wondering, why then could in the Court of Appeal, set aside, but probably even state that let it go back to the High Court for that form of proof before another judge, and again also not condemn him to pay costs. I'm looking at him in terms of somebody who has gone through a lot of suffering in the detention. During those days, of course, the system used to detain people, and we know what used to happen. So that's why I was just wondering whether the court maybe was not too harsh, not to pass judgment, but just to, to question the issue of the jurisprudence around that. But let me leave that for now, and I go back now to the other issues. We are now no longer on jurisprudence. Now, this is about now your CV, which is quite again a long one. I must commend you. It's a booklet. You've sat in many committees. You've gone through many positions within the judiciary. In fact, I would say that if we were to talk of a walking library of the judiciary, you would fit in that description. You understand this institution, the history and everything and all that, and you've worked generally here right from the university when you were admitted, except for a few months, with Mogoli Musaga, but basically you cut your teeth in the judiciary. Now, which brings me now to the following issues. That I did a lot of litigation in my early years. Actually, out of my 30 years, I would say 20 years I did litigation. And I used to come a lot to these courts, a lot. Now, my only worry, which now maybe you could answer to, is that the issues we're grappling with then, files getting lost, when you are trying to process bail for clients, accused persons who had been caught on traffic here, these cells. In fact, I'll tell you, my lord, I was also a victim of these sales at one time. I was caught in a traffic matter right outside here in reinsurance. I refused to pay the bribe and I was brought to the cells, put in that basement. Remember, there used to be a basement there. And it was terrible. Even by the time I'm going to the magistrate, it was really, I defended the matter. I defended myself until, when I was acquitted. But the issues we were grappling with then were quite severe. And they never seemed to be resolved. In fact, to me, the resolution of this issue started now post-2010 constitution after Mutunga now came. That's now when we started resolving some of these issues. Which now brings me to the question, how does that now relate to transformation on your part? Because these are the times now when you're in charge of the administration, but we are facing all these challenges. And there were many. Actually, I would, if I were to start now listing them, would be here probably for the rest of the day. So I don't know what would be your response to that in terms of performance vis-a-vis satisfaction to the members of the public, including us who are consumers of these services, who, I being one of them, who had to go through all this harrowing experience to a point where there are many lawyers actually who just abandoned litigation because, they were getting tired of these, issues. I don't know what would be your take on that.
Thank you, Commissioner. Yeah, true, there were many problems, many, you have enumerated them. I'll just give an example to illustrate how far or how serious those problems were. You talked about ourselves. Trying to get funds to renovate the Supreme Court building was a ceremony. And so one day I invited the PS at the time of Treasury to come to the court. And I took him to the cells and I asked him, how long can you survive here? And he sympathized. I went back, he did nothing. And he was brought to those cells one day. He is deceased. But he was brought and I went to see him. And it was not a very good sight. But just to demonstrate that you may have these very grandiose ideas, you may have plans, but if you miss two things, financial resources and human resource, you will not achieve much. And although we had great ideas, how we are going to build courts, how we are going to renovate courts, the money we are being given is what you can describe as an alm, just a token. And so you could do one court for 3 financial years because of the kind of money you are being given. And so everything else that any transformation agenda has to achieve, money comes first. Without money, you're talking of small claims court, you're talking of AJC, AJS, you're talking of all these other interventions. It's just a talk shop. Money first.
That's true. I agree, my lord. But my only worry again is that even issues that didn't require a lot of money, like files getting lost. I remember those were the days of call-over. We had serious challenges. In fact, the clerks were the king and the registry. They literally used to ride roughshod over us, those days. So even in terms of staff performance, now I'm talking about the judicial staff, it was a nightmare besides issues that probably could also have required money. So, and every senior lawyer you talk to will tell you the same thing, how Herculean a task it was, being able to conduct litigation here because of the many teething, issues. So still, because you see, you talked a lot about, I picked what you picked about, we talked about pension, the medical scheme, that, okay, those are very good things for the staff, but in terms of the outsiders, the consumers of justice, I'm still looking for any transformative agenda that impacted on the consumers of justice besides the staff, within the judiciary. Not to underestimate the importance of taking care of them, but to the outsider, for them feeling the impact of that, transformation within the resources, where you can be able to put little money on where there's high impact, I don't know whether you'd see, yes. Give me your view on that.
Yes, we face challenges with the files missing. It was a nightmare even for the administrators. Again, lack of incentive on the part of the staff. Of course, we expanded the registry to be able to accommodate this. We didn't have computerization then. We tried but failed very many times due to resistance. But again, the issue of integrity was dealt with because the commission at the time, just like this one, took seriously issues of infraction by staff, and a lot of staff were disciplined. But I believe there were also many things that were done during that period that impacted on those who came before us. We in most courts, we put up signage. A lot of courts in the country didn't have signage. You'd drive towards Meru and you'd not know where Chuka Court is, and every court got signage. We employed interpreters to help with court interpretation. Few courts got ramps for those who are not able. We even installed a lift here that I don't know whether it is ever used at the time. And therefore there were few things that were done. But again, the numbers were really, really few.
Yeah, that's true. Yeah. That's true, my lord. Now, you've mentioned about the computers, the ICT. In fact, that was the other issue I was coming to. Because there was not even any attempt at that time, because this issue has become, we keep saying that it has become a tired story where we keep talking about it and we're all guilty of it. But you see what I noted is that even during that time, there was not even the slightest attempt, even the basic infrastructure. This one of the candidates here who talked about when he went to Lesotho, Swaziland, and very early, that is in the 90s, he found already, there was automation. In fact, most of the jurisdictions have already done it. We are in a very peculiar situation whereby we are very ahead technologically, but in terms of automation within the judiciary, we've just not been able to manage it. It's now that we are now trying, but it's still auto manual. You can't really call it automation. So even then, there was not the slightest attempt, even with whatever little resource that was there, to start some semblance of automation now from where we could have been able to pick up progressively. I don't know what again was why there was no some attempt or some reasonable foresight on seeing that this is the way to go in terms of improving not only productivity but efficiency. I don't know what was the challenge.
There's correction that there was no attempt. There were many, many attempts. I can tell you, if you remember Justice David Porter, from those years, one judge who used to go to court with a laptop and record, or rather type, proceedings. The Chief Justices that to even Justice Chunga, every time there were attempts, but the resistance was too much from the users, the judges themselves. Some would tell you that they can't imagine taking proceedings without writing, that their brains work in a way that it flows through the hand. They agreed at some point that we now train them before we roll out, and we took the judges to training, and they agreed to get out of this building to go to Westlands to be trained. I'm talking of the late 80s, early 90s. We bought laptops, and when some of them were retiring, those laptops were returned in the box in which they were given to them without being opened. Resistance was one of the reasons why a computer was not rolled out at the time. But I can tell you also that many committees were set up, many. Went all over the world, Ethiopia, Singapore, all over the world, and came with ideas. Again, just reports as usual. And so for me, this is a very, very important point to which computerization must be moved. The retired Chief Justice was bold to start the e-filing against all discouragement from some people, among us, that we were chewing more than we could swallow. I stood with him to say we must begin somewhere, because I've watched this song for too long. And so computerization, I think, has begun. We just need to escalate it.
Absolutely. I was just also referring to the, apart from the resistance by the judiciary, the judges rather, probably there should have been an attempt now by the administration that you are heading, at least on the part of enterprise resource planning, now the administration part of it. Because, see, one of the challenges that lawyers have grappled with, which is now being resolved, but which should have been resolved then, even e-receipting, that is something that could probably have been done. The finances, because when you go through audit reports, you see a lot of gaps in terms of how the leakages, So basically the administration part to just make, where you're able to even interconnect with all the court stations, etc., etc. But that seemed not to have happened. But unless you want to say something.
Receipting again, an area where we lost a lot of money is because of the requirement at the time that you could not receive money on behalf of the government without issuing official receipts, the yellow ones. I think that was the color from the government printer. So you couldn't come with any other method. We tried even to do one with watermark. But again, they said, no, you have to stick to this. And I think commissioners here who have worked in the government, and they'll tell you that you couldn't just start anything else to receive revenue on behalf of the government.
Actually, that's the same reason we were given by CRJ when our committee, and we said, no, you must get a solution.
Right.
And we told her that by the time you're coming, come with a solution.
Right.
And she came with a solution.
Thank you.
And now we are e-receipting.
Right.
So now, let me move from there to the issue of, there's a case that was, I just asked myself, because Justice Majanja again interrogated one of the candidates here about the Mutugi Bar case in the early 90s. And we used to read a lot about it, and where in these cells, the accused persons were being confronted even with the feces, within the cells. Now, I don't know what steps, because that time you are a deputy registrar in these courts, what steps perhaps the administration here would have taken to ensure that those kind of things, because sometimes I shudder to think that if these things were to recur again, of course chances are remote, but you never know about the future, whether such issues could have been avoided by those responsible even in the administration to ensure that the security agencies do not use the courts that way, where they are having access and contaminating the facilities that belong to the judiciary to achieve ulterior motive. Because you are at that time, in the administration. Could you tell us a little bit about what could have gone wrong, whatever it is? I know the system was very different. We were working under very difficult circumstances, but perhaps you could also indicate so that as a Chief Justice, as you go as a Chief Justice, you're able to put in mechanism that ensures that such, abominable actions never happen in the precincts of the Tower of Justice?
Sorry, Commissioner. So some particular incident occurred?
It was being said that during the Mutugi, George Anyona and the like, when they were coming in the cells, they were even finding feces even in the cells, just to torment them, just to torment them within the basement here.
That's unfortunate.
Yeah.
Very, very unfortunate. But as you said, in context, things were very different then. And as an administrator, you didn't know what prison warders carry as they go into those cells. I don't remember this particular incident, but unfortunately, I don't think in today's Kenya such a thing can happen. I don't think that you can bring people to court to torment them where you have brought them to seek justice.
Yeah. All right. Now, then let's move on to, I would want to capture now the issue of the kind of a Chief Justice that you think, you fit in terms of, in comparison with the others. I've done a bit of research over the time in respect to various Chief Justices. Of course, all Chief Justices are different. Perhaps if you became one, you could even probably be better than even the past one. So we cannot be tied to the past Chief Justices. But I've been talking so much about the foreign ones. Today, I want just to restrict myself to the ones who have been Chief Justices in Kenya. And one of the candidates here said, and I think I thought that I agreed with him on that the two Chief Justices that I can pick in my mind who are renowned, we keep quoting them and we thought they were very strong, was C.B. Madan. I don't know that you'd agree that he's a judge that we respect highly.
Yes, very, very highly.
Very, very highly. In fact, probably you could even be rated as number one. I don't know. Then the other one was Apalu. Apalu, I think he became our Chief Justice in 1993. Those two, there was even some mention about them here. Now, but see, now what I noted about these two Chief Justices, before I come now to my question, is that now, like Madan, for instance, he was an advocate for 10 years. Then he was even elected to the Nairobi Town Council. By that time, Nairobi was a town council. It was not a city the way it is today. Then he was elected to the Legislative Council. He became a permanent secretary at some point in time, became a cabinet minister, then eventually became a judge, then became a judge of Court of Appeal, and finally became a Chief Justice. And I think his experience cutting across all these areas prepared him very well to become, a great Chief Justice. I looked at Apalu, same thing, and different situation, but Apalu, what I noted is that he also practiced an advocate for 10 years. He was heavily involved in fight also for independence. He was defending actually a lot of people who were being arrested by the colonial government then. He even is renowned for representing rioters, the famous Anloga riots. It was called Anloga riots. Then eventually became, of course, a judge, then became a judge of Court of Appeal, then became Chief Justice. 3 successive regimes in Ghana tried removing him because of his independence. Now, so I've given you those scenarios. Now, which brings me now to the issue that, you see, I don't know how you'd respond to the fact that for you, you've been mainly in the judiciary, right from the start up to now, which is not a bad thing. I'm asking this question specifically because we've also asked other candidates. Don't you think that this lack of the outside experience, which will be able to give you a helicopter view, that will be able to give you ability to think beyond the judiciary, could be a disadvantage and probably could affect your ability to become, the CB Madan and Apalu and all those others?
Thank you, Commissioner. Yes, I didn't work, I didn't get the opportunity to work with CB Madan, CJ. But I worked with Apalu, CJ. He served here first, up to the Court of Appeal, went back to Ghana, became CJ in Ghana, returned to Kenya as Chief Justice. And apart from being my boss, we were very good friends. And so what you're saying is true, that they had this very wide experience, and that experience is necessary. And I can say that for me, being here has also exposed me. I was not tied to a rope in the judiciary. I have been able to interact. I've been able to interact with the top judges in the world. I have links with the judges even in the Supreme Court in the UK, and I'm exposed. My having risen to me through the ranks, seeing where we came from, where we are at, gives me a chance to chart where we should go. The two Chief Justices that you have identified, I can't talk about CJ Madan. A lot of CJs, like CJ Apalu, enjoyed his court work. And so he was very good in his jurisprudence, wrote very simple English, and that's what he taught me, that when you are writing not to counsel before you, you are not writing a book or a treatise, you are writing to the parties who come before you. Use simple English, short sentences. And so jurisprudence was excellent, but I can say that he did not bother much about administration, and a lot of CJs didn't. So there are few who did, yes. So I agree that you can have both. The person who has been out there but hasn't been here, so comes in here, spends 2 years to learn the ropes, is inducted. With his eye view position, he still will not understand the judiciary. It's one thing to appear before judges and magistrates in court as an advocate, but when you come in, you take a bit of time to learn the complex nature of the institution.
Okay, my lord. Now, let me, because of, I know the chair said that this time she'll be very strict, so I'll spend the other 5 minutes just winding up on my questions. I had more, but I think we will have the disadvantage of time. Now, what I noted, my lord, again, maybe you could also explain. You see, we had put all this biodata in for the public also to interrogate it, and I think, so this is a question I would not want to leave. I noted, my lord, that you are a police reservist from 1994 to 2004, basically 10 years. I didn't understand that, because this was a time when you are the chief court, even up to when you're chief court administrator, even registrar, in charge of the institution. So I didn't understand how that was working, because I even saw a letter of promotion where you are being promoted to a higher rank. And the way I know, because I also understand police by virtue of my interaction with police in my previous roles, that a police reservist actually is a police officer, except that maybe you don't enjoy certain perks like pay, and all that is voluntary, but in terms of chain of command, you're actually a police officer. So I'm wondering, how was that working? Because, you are overseeing the entire administration of the judiciary, including overseeing the magistrates at that time. And because I was asking myself, if a police are being accused of certain misconduct, people are complaining. Those were the years, especially the early years when police were notorious. Really, really, really notorious, But again, you're here and, you are police reservice. How was that working? I would want to understand.
Thank you, Commissioner. As a young boy growing up in the village, I lost a brother and in circumstances that were criminal. And my dad, of course, there was a trial in court, and the suspect was set free. And my dad thought that it was due to poor investigation. And so he urged me over and over again, when you grow up, I want you to be a very good policeman who can investigate crime. And so he prodded me quite a bit as I grew up. And as a young man, young men, these days, the young ones have such high dreams. Our times wasn't that high. And so I joined the police, not to be a policeman, but for two reasons. One, to satisfy my dad's dream, my late dad's dream, that I eventually got there. And second, as a community service. And all I did is to train the police. I wasn't chasing criminals in town. I wasn't breaking doors, but just to train them on the use of firearm, on how to arrest, something that was very useful at the time, because a lot of police officers at the CID training college benefited from my knowledge of the law. So I did it purely as a community service.
My only worry is the conflict, because I'm imagining like CRJ with such vast powers over the administration, then also having ties with the police where they're also answerable. Because that time you were answerable to the provincial police officer, because that was now the person who, to me that creates an untidy, relationship in terms of holding also the police to account from the judiciary perspective. So I don't know, because I'm asking this so that we don't put you up there. Then you're in other situations. It's a question of judgment. I'm not sure whether I hear where you're coming from, but again, I'm just asking whether, when you consider the judgment around it, whether it was the right thing to do. If you think it was the right thing to do, of course, I'll not pursue it.
There was no situation of conflict at all during that period, at all. I didn't see any. I didn't think that one would arise. I wasn't sitting in court as a magistrate. There would be conflict if I was making decisions where policemen come. But this was something that I was doing once in a while when I'm called upon to do that. And so for giving to the community, if that's how I saw it, helping the police not to use their firearms in a way that cause harm, that's how I thought I was doing it. And I think to the best of my judgment, I reflected. My bosses knew I was doing it. But of course, when I became a judge, of course, then I left.
I was asking that because you recall this reservice was so notorious at that time, the killings, the extortion. In fact, subsequently, you recall that's the reason why that arrangement was banned, because they actually got out of hand. That's why I'm asking about those issues. But let's leave that. My final two questions. In a collegiate court, sometimes they say there could be a tendency where you have 3 judges or whatever the number, some very hardworking and one who just, slips through without doing much under the cover of the others. Now, I don't know, as our Chief Justice, in terms of improvement of the productivity and making sure that everybody is delivering, I think that's one of the reasons why my colleague was pursuing this issue of every judge writing. And I agree with you again, it may not be practical, everybody writing, but at least making sure that everybody again is not taking cover under the others, and overworking them. I don't know what would be the steps that you are taking now and what you would take also as similar steps to make sure, that productivity is, cuts across.
Thank you. There's a judge who once described a situation you have just narrated as a car that is stuck in the mud and everybody is pushing it. Among those pushing it, there's a fellow who has just pushed his hands on the car and taken a posture of pushing, but only his hands are in touch with that car. And so we have situations, obviously, in the judiciary, in the courts, where some people work so hard and others have just put their hands. Again, it has to be appreciated that we are not the same. We have in the judiciary those who are very quick, extremely quick. There are judges who generate drafts in a few hours, and there are judges who have to be pushed to bring drafts. It's a question of performance, and it's a question that must be addressed. We get all these returns every day, at least in my court. Every day I get returns showing how the benches performed, 9 matters were listed, how many were heard. It's the same thing I believe with the other courts. What do we do with these returns when they are submitted? Do we make follow-ups, or do we wait to put them in the soldier report after 1 year and identify those who have done well and give them certificates? I think time has come that those performance reports must be implemented, that those who have put their hands on the vehicle must be told that you have to push, and that if you do not push once and you do not push twice, then you are incompetent. If you are incompetent, then you know where next stop is.
Okay, thank you, my lord. There are many more questions that I've asked based on my constituency, but time does not permit. I wish you well. Thank you very much, my lord.
Thank you very much, Commissioner Jeru. Your Honor, just a clarification, and this is out of ignorance because I don't know how the court works. But if you have selected a bench, let's say 3-judge bench, and one judge is generating the draft, but eventually you meet and the decision is collective. The decision is collective, discussed by the others and may be passed. Does that judge get credit for that hard work? Because then they see it, they do the research, maybe the whole night, on behalf of the others, and they meet, do the conference and make a decision. So how does it work? Does that judge get 50% of the credit, or can I claim as the judge who came up with the draft that this is my write-up, even though the decision is collective?
If you see judgment of a collegiate court, you'll see at the top, it has the names of the judges who sat in that matter. It's a judgment, it's even headed judgment of the court. If you write your own judgment, it's judgment of Ouko JA. That's my judgment. I've put all my thought in it. I've reasoned in it. The language is mine. But if we have had a matter and we have conferenced and we have agreed on the outcome and we assign a judge to go and generate a draft, the judge generates a draft according to the way we conferenced, putting in a little more, actually much more, because the whole body becomes the work of that judge. But this transformation of that judgment from the time it is circulated to the other 2 judges to the time it is delivered, because the other 2 judges will also have an input. There are occasions when you generate a draft and share with colleagues, and when they return the judgment to you, you can't recognize it. Long time they used to use red ink. It will all be red. And so when it is finally ready for delivery, it cannot be a judge's decision. It's a court's decision. Thank you.
Thank you for that clarification. Now I will call upon Honorable Attorney General to ask you questions.
Thank you very much, Honorable Madam Chair. Good afternoon, my Lord Judge President.
Good afternoon, Mr. Tony.
I seek your Lordship's indulgence in taking you back to the discussion on transformation and court administration. You have told us at some length of the problems and challenges that face the judiciary currently. And it is on record that there have indeed been numerous task forces, committees, you name it. I can recall under Chief Justice Okello, various committees, the Onyango Otieno one and so on. You yourself, my Lord, chaired a committee or a task force and made substantive findings and recommendations. And there were even committees that sat to implement those recommendations. Now my concern is this, my Lord. Despite that, we still appear to be stuck in the mud. There seems to be an inherent problem within the judiciary in achieving the objectives. Your Lordship used words like the lack of coordination, the lack of focus. There are too many committees and they adversely affect the work we do. Judges are not quite involved. Now, my Lord, what is that inherent problem that prevents the judiciary from seeing the light of day, from implementing those recommendations to their logical conclusion? Some of these reports date 20 years. Some of the recommendations are still stuck. Braille machines, something that was recommended X number of years ago, still unimplemented. Why? That's my first question.
Thank you, Mr. Attorney. I said earlier, we need to focus now on seriously implementing these recommendations. I do not think, from where I sit, that we have been focused in implementation. We've been focused in generating more and more work, replicating what has been done before. The problem we have in this country, in the judiciary, is simple. Backlog, delays. Backlog, delays. Issues of corruption. And all those solutions to all those problems are in those reports. Those reports have been collapsed into SJT. Those problems are in our strategic plan. It has been that we have not paid attention to the implementation, which is one area that the next Chief Justice needs to take on. Because all those reports say at the end that there will be an implementation mechanism, there will be monitoring and evaluation mechanism to ensure that we achieve the objective of those reports. They were not done in vain, and as you observed, there are many. I counted, I think, 15, and if you read all of them, they say the same thing.
So, my Lord, what then is your Lordship's vision for the judiciary? If God grants that you become the next Chief Justice, you will have like 10 years. What is your vision vis-a-vis that stagnation in these reports and recommendations, so that in the course of your tenure, you can leave a legacy where indeed we can sit here, those who will be here, and say, yes, the judiciary is now out of the mud?
In one sentence, restoration of public confidence in the judiciary is my main agenda. Of course, there are many facets to that, many. You must make work move, reduce waiting period. You must make people work, go to court. They are going to court right now, but I don't think we are working smart. And so my legacy is that of a satisfied litigant who comes to court and gets justice expeditiously.
And my lord, apart from moving the workload, the backlog, what are give us another 2 or so steps that you will take, pragmatic interventions that your lordship will take to achieve that objective?
All to do with case management. The first one is digitization. As I said, we have started off very, very well. We have the e-filing now. We have CTS, a case tracking system. I want to leverage on that because with computerization, all these jurisdictions that have progressed is because they saw the potential of computerization and implemented them. That's one. The second one is to look at other ways of taking this heat from the court, but still meeting the same objective of reducing backlog and delay. We have court annexed. Now I'm told it's called court mandated mediation. I'm told it has worked very well. In a few years it has been there. I'm told it has released in the economy 15 billion shillings. That's an area that we need to strengthen. Alternative justice system. That's a system that is at its infancy. It hasn't even crawled. We need to look at it again and move it to where it should move to. We have also other dispute resolution mechanisms that need to be looked at and pushed up. I've been thinking also of something that is in our laws but has been only tried once or twice. That is the commissioners of assize. There's an act of parliament that allows the Chief Justice to appoint lawyers in private practice to help the judiciary with the hearing of cases, given our numbers. The last one, I do not think we achieved what we set to do. Because they came in and they just got into the stream. And so looking back, we can't say whether there was any tangible result that came with that effort. And so it's an area I've been really thinking about because it's cheap. It's cheaper than hiring judges. You pay them an allowance. But this time, they have the work they're coming to do must be defined. Are you coming to do 20 cases? Are you going to do 50? Within what period? I've been thinking about it because that act has not been repealed. It has been used before when we were having shortage of judges. So I've been thinking of that. Small claims court, again, from what I read, the Honorable Acting Chief Justice has operationalized it by appointing, I think, 2 magistrates. The purpose was to make this thing vibrant and let people know that it's there, because it's going to take away a lot of pressure from the High Court and the Magistrates' Court. So those are the areas and many others that I will come up with to try and realize the confidence in the public.
Would there be a conflict, now that you mentioned commissioners of assize, who would be coming to do the work of a judge, would there be a conflict with the Constitution?
The framers of that law, perhaps in its context, maybe at that time we didn't have enough judges, but I think even those who served, there were mechanisms to make sure that they were not conflicted. For instance, Commissioner Shah was a prominent practitioner from Mombasa. He was working in Nairobi. So you don't work where you practice. And again, the files that are allocated to you, you have to confirm whether you are conflicted.
Thank you, my lord. Let's move on to the aspect of judicial discretion, which we discussed earlier. And I'll limit my question to the aspect of ex parte orders, which your lordship also addressed. Now, in the old days, you will recall, my lord, the Chief Justice sat and was a member of the Court of Appeal and also of the High Court. The Supreme Court didn't then exist. And one of the reasons, amongst many others, was to mentor the judges, especially in the High Court. Now, you expressed grave concern at perhaps the manner, in some respects, in which ex parte orders have been granted. And your lordship said you would look at this very, very carefully. And this aspect, as your lordship knows, has been a bone of contention with the executive and even with the legislature. What I should like you to comment on is, as you look at this, how would you address the problem ensuring the independence, the individual independence of the judge, and also without undermining the independence of the other two arms of government? And by way of background, your lordship will recall that this has been also a subject discussed within the judiciary. There have been workshops at the Judicial Training Institute specifically to address this. There have been meetings here, even dating back to the tenure of Chief Justice Emeritus William Mutunga, in an effort to resolve this problem. His lordship even invited other players from the agencies involved, etc. How would you address this, my lord, as Chief Justice?
What I was told when I joined the bench as a judge by Mr. Justice John Wycliffe Mwera was that issue an ex parte injunction, ex parte orders in exceptional circumstances. He told me that if you're working in Meru and a case comes before you that has been that you have certified urgent, you are working in a small station, that this dispute could not have emanated 10 kilometers away. The best thing to do is to direct that the application be served on the other side. If it appears so urgent, even say, and appear this afternoon, and by the time they appear, they may even have agreed, even on status quo being maintained. That was the teaching and the lesson some of us got. And true, we've had discussions on this, and true, no Chief Justice can direct a judge how to do his or her work. And so to me, it is just to keep reminding ourselves that there is no life and death situation that would call for such drastic orders in certain situations. One judge used to say he would never give any ex parte orders. And I can say, which judge? Mr. Justice Kuloba, never. Because he says, oh, they are going to do this to you. If they do, we will undo it. Okay, that may have been extreme, because there are situations that are also extreme, where a property is about to be demolished in the afternoon, where somebody is about to be committed for contempt. So you are forced to give those orders. And so it is an area that I think, as a judiciary, we can't have rules on how to do it. The rules are already there. It's something that we need to change as a family, look at together once again. And not saying that you cannot issue ex parte orders. You can. There are situations that call for that. But when it is issued willy-nilly, that concerns people. And sometimes examples that are given is that I own a little shamba in Makindu. SGR is coming and I've been promised compensation. My compensation has delayed. I go to court and I stop the entire SGR. It either means that we haven't read the pleadings. It either means that we do it mechanically, like some judge used to. He just used to ask the clerk 14 days, which date? He's told 5th of May. He gives injunction and tells you inter partes hearing on the 15th of May. So either we do that mechanically, but it's a problem that concerns even the investors.
Thank you, my lord. Would there be a case of disciplinary measures being taken in the event that it was established that this discretion had been abused? It has not been exercised judiciously.
Obviously, if there is evidence of impropriety, if there is evidence of incompetence, those are grounds recognized for disciplinary action.
And your lordship would take that course of action in an appropriate case?
Yes, I would.
Thank you, my lord. Now, our national values and principles of governance, as you know, my lord, are in Article 10, good governance, integrity, transparency and accountability. Now, what would you see the role of the Honourable the Chief Justice in terms of accountability?
Thank you. The Constitution starts by reminding us that the powers we exercise are not our powers. They are powers donated to us by the people. And so at every level, we are accountable to the people. They are our employers. Everything we do to satisfy their needs. And so there are laws that, apart from the fact that there's an appellate system that is also a means of accountability, the law requires, the Judicial Service Act requires the Chief Justice to tell the country what the judiciary and the administration of justice in general has done, and what were the challenges, what were the achievements. And that's a requirement of the law, which I think the Chief Justices have performed quite well. Apart from this observation that the National Council on the Administration of Justice brings together very many players. And when we give the state of the judiciary and administration of justice report, equal chance ought to be given to the other players in the report. If you look at the report, 3/4 is judiciary, very little about the other arms. Yet it's supposed to give an overview of what we have done working in synergy with the other agencies. Again, NCAJ as it is has done also some great work, but could do more by having frequent meetings, focused meetings to address some of these things in order of accounting, so that we can account to the people. The one area I commend NCAJ under the leadership of the retired Chief Justice is the manner in which the COVID situation was handled by the agencies in this council. They came together, they agreed what the police were going to do, what was going to happen in prisons and in courts. And that's how we need to work, so that the synergy, even in terms of trials in court, we need to be able to coordinate and cooperate.
My Lord, one of the tools that have been introduced in the recruitment process towards better accountability and transparency is a requirement for judges and judicial officers to make their wealth declarations, which forms part of the material that your Lordship has tendered here. And indeed, even this requirement that your interview be broadcast live. Would you consider these to be impediments in recruiting the best that is available? I say this because there have been whispers, maybe loud whispers, that because of that process, there are people out there who are good, but who shy away to embrace this process, thereby depriving the Judicial Service Commission of interviewing the best and the brightest. What would you say to that?
In the past, there has never been anything as opaque as the appointment of judges. I would be told to identify X and to be at the CJ's chambers at 6 p.m. to be told, without being forewarned, that the next day you are going to State House to be sworn in as a judge. And you are warned too that don't tell your wife or your husband. There can't be anything as opaque. And so you would go to State House and people would watch at 1 p.m. You've been appointed a judge. And it took again the initiative of the late Mutula Kilonzo to start thinking of a transparent way of recruiting judges the way magistrates are recruited. And there were examples in the world where this has been done. At that time, he wanted us to amend, I think it was section 87 of the former constitution, so that we introduce a competitive way of recruitment. And to me, this is the best way. And if you have something to hide, then you don't present yourself. If you fear that you'll be scrutinized, it's a public office, scrutiny is always there. So whether you use the old system or this system, you will still be scrutinized. And so for me, this is the best that ever happened. I think the advert was clear, and the previous adverts have always been clear. You have never said that only the following qualify. And so for me, I wouldn't agree with the talk out there that some people who have good qualities for these positions are inhibited by the fear of being exposed in terms of your declaration of wealth, in terms of the public glare through televised interview. No.
Thank you very much, my Lord. I move on to my final area and my final question, which is this. In the course of your career in the judiciary, you must have come across phrases like bench fixing, shopping for judges, allegations of outright bribery of judges in the various courts. That's in the public domain. And the phrase, why hire a lawyer if you can buy a judge? Now again, the subject of corruption is not new, and it has been addressed by various committees. Under Chief Justice Evan Gashero, every couple of years, a committee which would go out around the country from members of the public and offering remedial action, sometimes on the spot, on the ground, and sometimes through the usual mechanisms. The surgery of judges in 2002, was it? 3, etc. And yet, my Lord, the problem, the cancer still persists. In recent years, it seems to be entrenched. You're seeking to become Chief Justice against that backdrop, where there is rampant corruption in the judiciary, real or perceived. There are allegations of cartels being out there, making all manner of deals. What is going to be different in your tenure, in your contribution as Chief Justice Ouko to the fight against corruption? How will you do it?
Corruption is a big problem, not just in the judiciary, but in the entire country, all sectors, all sectors. And it is only in the judiciary that we have looked inwards, that we have done introspection. All these reports you talk about were all meant to address the issue of corruption, all of them. And Chief Justice Gashero, you are right in saying that he had a plan to have a biannual team that would change every 2 years to go around and collect views. And you are one of those who did the last one, done very differently from the radical surgery. Radical surgery that saw some sick people go, but also those who are not sick. It also left those who are sick to remain. Yours was different because you are able to hear the parties, the person complaining and the person being complained against. So there must be, from the reports we read, there must be corruption. But one credit is that the judiciary has always taken its own initiative to fight corruption. Corruption is not like, what can I say? It's like night running. Nobody runs, a night runner doesn't run during the day. It is done in the dark. It takes two to tangle. And so, even as we try to address corruption within us, we also must be able to have corruption addressed without the judiciary, outside the judiciary. There are many mechanisms that have been put in place. We have laws to deal with this. Public Officers Ethics Act. We have the Integrity Act, Leadership and Integrity Act. We have even a new one, which I saw recently, Public something, principles, values and principles. Values and Principles Act, I think that's what it's called. And so we have filled our libraries with these laws, which are not supposed to apply only to the judiciary, but to the whole of public service. So for ourselves in the judiciary, my concern, if God willing, you grant me the honor, is first of all, just to appreciate that there's no purpose for a judge or a magistrate to take a bribe. If you look at what the commission has done to us, the salary of a judge, the salary of a magistrate, if you leave out the salaries, the perquisites, the benefits, you have a car grant, you have a medical scheme, you have a group accident policy, and you can go on and on and on. Why would somebody tempt you with money? So it's time also for us to think whether we joined the judiciary to enrich ourselves or whether we joined it to provide service. The Ombudsperson's office that was established by Chief Justice Mutunga is there. It is the office that we must strengthen, give it the necessary retooling. We must take seriously these declaration forms. I don't know what they do with them. I know I'll soon be asked by Commissioner Oluwande about those. Very good things that we filled since 2005. Nobody checks whether the car you said you had in 2009 is the same one you have today or you've changed it. So they come in heaps. I don't know where they are kept, and the law says even after I retire, you keep mine for another 5 years. What do we do with these things? They were meant to serve a purpose. And it's not just the judiciary. This applies to all the ministries. We, every 2 years, initially it was 1 year, every 2 years we fill these things. There must be a purpose. And so there will be a different approach. We will be pragmatic. We will encourage judges, magistrates, judicial officers, everybody, staff, to serve with dignity, to serve with integrity.
Thank you very much, my Lord. I am most obliged for the answers your Lordship has offered. And that should be all from me, Honourable Chair. Thank you.
Thank you very much, Honourable AG. Thank you, Your Honour, for those answers. Just a follow-up question, Judge. Can one feel wealth declaration and still be corrupt?
Can one feel wealth declaration and still be corrupt?
Yeah, because I mean, they can't be the only indicators. I'm just thinking I can do a good job filling them, but still.
Yes, the thinking behind those declarations was that they were going to be used to gauge how your wealth grows or diminishes. Of course, it says just give the one for, indicate the wealth of your spouse and for your child below 18. It cannot be a correct indicator. People can still acquire wealth and register in companies' names and in friends' names. So the objective was good, but I don't think it is foolproof.
And I think the law, Your Honor, talks of public officers, if I remember correctly.
Yes, it does.
So what happens when we want to hire people who are not from the public service, and yet the law talks of public officers? What do you think should be done?
I think it's also a requirement. If you want to cross the public service, then you must declare also what you are coming in with.
Okay.
And then we are able to gauge you that you've been here for 2 years and your wealth you came in with from the private sector has doubled.
Okay. Well noted, Your Honor. I will now ask Commissioner Shohi to please ask questions. Commissioner. The microphone is not working, the technical people. Commissioner, maybe you can come and ask from here. Or
Sorry for that, Chair. Honorable Judge, good afternoon.
Good afternoon, Commissioner.
These machines, sometimes they behave that way. May I also confirm, Madam Chair, that what the judge have said about the declaration of wealth is very correct, and that is what pertains to public service. Judge, Honorable Judge, I have been listening very carefully since morning about judiciary and all the things that go there. And I see from your CV, you have literally spent most of your life within judiciary. And you are once a secretary of this commission, I think once 2002 and 2004. I'll write you very candidly and very openly and sincerely when you look at the commission seated here this afternoon. And I want you to remain on the reign as chairperson of the commission. In your view, can you identify 2 areas that the commission needs to do or to address for us to support what the judiciary is doing? 3 key areas within the commission that we need to do.
Yes, I sat in this commission, and it is totally different from the one I sat on. In terms of even the transaction of business, it's completely different. And now under the Constitution, you have powers. One area that I want to talk about is the training area.
Training.
Training in 2 levels. The first is the domicile of the training institute itself, where it is located. And second is the training opportunities for everybody in the judiciary. The training institute, I'm told, is being evicted from where we have been for many years. And I don't know whether the Commission has identified a place for it. It concerns me that when other arms are able, and I'm aware, one branch is doing a big college where people will be trained. Another one is doing also a big college where service people will be trained. And when the judiciary asks for 1 billion shillings to be able to buy the property, it is given to another arm. Is that fair?
Okay, that's one concern.
Yeah, one concern. The second one is the training. There are grumbles out there that training seems to focus more on judges, a little bit less and lesser, a little bit less on magistrates, and perhaps non-existent for the staff that support our services. There ought to be equity in training. It serves a very critical purpose, but everybody needs to get a chance. But while still on training, training must be coordinated, properly coordinated, so as not to interfere with the core work of the court. You go to some courts and you're told that a judge or a magistrate has gone for training. Sometimes they stay for 2 weeks. Perhaps 1 week is not even in training, but taking advantage. So those are the two areas.
Okay. Now, let's also look at your internal mechanism, your internal management. I've noticed that you're actually a member of the Judiciary Leadership Advisory Council. If you get this position, what kind of linkage would you have between the council and the commission in terms of feedback from the two organs of judiciary, the commission and the council that you sit on?
Yes, I said earlier, Commissioner, that council needs to be strengthened. As it is, I think we are only 6. I think it needs to be broadened. During Chief Justice Mutunga, I think it was bigger. I know judges who are in it who were not presiding over any level of court. There are magistrates who can bring value to the council, and of course even some judiciary staff. So the first thing is to strengthen the council, because the Chief Justice and the Deputy Chief Justice are members of JSC. To me, that would be sufficient linkage with the council.
So if I get it correct, in a month or in a year, how many times do you meet as a council?
It's unfortunate. We don't have a timetable. We meet on need basis. Which is another weakness of the council. There's no structured meeting schedules.
So if someone was to say that that is one of the weaknesses that someone can say, yes, from what you have been meeting as a council, not met for a year or for a month, you are the chairperson of the council, you are also the chairman of the commission. Doesn't seem to have any kind of communication. Would one belong to say that you need to strengthen your internal mechanism to ensure that you are able to discharge your duties even before you go to external?
Yes, there's a weakness that because of infrequent meetings and also because of lack of communication on what the council does, that diminishes its importance.
So if we give you this position as a chairperson of the commission, what did you do different?
First, I'll strengthen the commission by expanding it to be representative of the people we serve. It will have a replication of the commission here, the JSC, because we'll also have a secretariat.
Okay.
It will have frequent meetings with the forecast agenda. we will be able to communicate with the people we represent in the council on the decisions of the council. Yeah, that's how I will deal with it differently.
Let's now look at towards the staff, the human resource department. And as you said earlier on, the human resources are very key factor in terms of productivity and efficiency. When you look at the staff, you're talking about almost 5,000 staff, not counting the judicial officers, just the staff alone. What do you identify as their weakness and their strength?
They are all mine.
The staff?
The staff.
Yes.
The staff alone, currently, it's estimated that the staff alone, other than the judges and judicial officers, count for 85% of the population in the judiciary. So a very big number. And they are actually the engine that run this machine. So their role cannot be downplayed. And so for them to be able to support the functions of the judges and the judicial officers, they must be resourced in terms of giving them the proper tools of work. The second thing that is very key also is incentive.
Incentives, yes.
So those two, give them tools of trade and give them incentive.
I want you to address the issue of performance and the measurement of their performance and how you'll be able to sanction non-performance.
Again, I'm not quite sure whether the performance management that is applied to judges and magistrates are also applied to the judiciary staff, but it is necessary that every officer who works in a directorate, I think directorates are evaluated, but if you are to go lower, I don't think there's any mechanism to measure their work, like the court assistants, like the secretaries, yet their work is measurable. You can tell how many judgments a secretary has typed. You can tell how many processes have been served by a process server. So there ought to be a mechanism of measuring their output and also of rewarding those who have met their targets and giving sanctions to those who have not.
Would you consider transfers as part of sanctions?
There were times where any transfer to some of the stations in this country was considered having been sent to Siberia. It was seen as punishment. Hence the need that arose to have a transfer policy. So it is not seen as punishment. For me, transfers has never been, if it is being used as a punishment, it has never been effective. If you are transferring me because I'm hiding files in Nairobi and you transfer me to Bungoma, I'll not have stopped doing that. I'll still, perhaps I even perfect it. So it has never been a way of punishment. I've never viewed it as that.
Honorable Judge, when you take this position as a commission, as a chairperson of the commission, and you introduce a transfer policy, as a chairperson of the commission, I want to hear from you very clearly, how would you regard a transfer policy in case you need to make that as a sanction? Do you retain the officers in the same stations or do you transfer them to what you're calling Siberia? I want to get it from clear as far as transfer policy you would recommend to the commission.
As I said, if it is 2 years, it is 2 years. Of course, there are exigencies of duty that call for perhaps a shorter time or even a longer time. But those should be exceptions to the general rule. But I repeat, I will not make a transfer as a punishment. That because I think you are not performing, or perhaps you are rude to me as you are Chief Justice, the solution is to take you to Siberia. Okay. There are no Siberias as far as I'm concerned, but places in this country, Kenya.
I talk a little bit about diversity, because it's also very clear in terms of the principles, public principles and the values in the Constitution. And that's the chairperson of the Commission. Diversity, not only in paper, but on the ground and in reality, is very key. If you get this position, what will be your take as far as diversity in terms of our staff, in terms of our officers, in terms of the entire judiciary? Question of diversity.
Diversity is a constitutional imperative. A diversity, I have myself exercised it where I work in my office. If you look at those who work with me, my driver, my secretaries, my assistant, I have embraced diversity in the form of regional balance, in the form of gender. So diversity is key, and whatever we do, we must always bear that in mind.
Okay. The other area I'd like to ask to talk about is financial accountability. I know you have been an accounting officer, you've done public finance, all those issues. In terms of enhancing financial accountability in the Commission, in judiciary per se, what kind of mechanisms are you going to put in place to ensure that judiciary remains accountable?
I think with the introduction of JFMIS, with the advent of the Judiciary Fund, with all those mechanisms for accountability, once the Judiciary Fund is rolled out, there should be a very smooth mechanism for accountability. But as it is, our local IFMIS and our directorate that deals with audit, and there's a directorate, audit, answers direct to this commission, risk and audit management directorate. Those put together and resourcing them would be key to meeting the optimal level of accountability.
Our judiciary fund is not yet in place in terms of funding. It is there in law, it is in the Constitution. In terms of the regulations, as we sit here this afternoon, the fund doesn't have any money. Now, if you get this position, what will you do to ensure, or what kind of an engagement will you get into to ensure that the fund is properly sourced? Two things that you do to ensure that the fund is properly sourced.
If you read the report of the task force that I was privileged to chair, one of the things that was identified as a mechanism of giving the judiciary financial independence was this fund, which would ring-fence the monies allocated to us. And I've been following keenly when the law was passed. Then there was pull and push regarding the regulation. I even attended one of the meetings with the delegated legislation committee. I've been very, very keen. And I'm aware that where it has reached is just a question of opening an account. Again, there has been a stalemate regarding some interpretation of two statutes. And looking at the stalemate, the solution, if you honor me, the solution, from what I hear, has brought us to a standstill, is an issue of consultation. That for you to open this account, yes, the chief registrar is the person to open the account. For you to open the account, you must consult with the National Treasury and with the Controller of Budget. And that's where we'll start.
So you as the chairperson of the commission, God willing, next month, how will you unlock this stalemate?
Yes, I'll call the two. The Controller of Budget, and I'll call also, actually three, the CS Treasury,
CS?
National Treasury, plus perhaps his PS. I think I've said Controller of Budget, and the Governor of Central Bank. So on a round table, we agree, because my focus will be in another 2 to 3 weeks. It's just opening an account. Unless I'm being simplistic about the problem, but that's how I see it.
Okay, the account is opened. Let's go to money.
Oh, money.
Get the money now in that account.
Oh, yeah, money. I'm glad to hear that the account has been opened.
No, the account is not open. I'm saying you have opened the account.
Oh, okay, sorry. Oh, okay. Right, we have cleared the first hurdle, now the money. I said at the beginning that the money has grown very impressively.
Yes.
From 800 million to, I think, currently 17 billion. Is to have, again, an understanding, the way money is disbursed, generally, even currently, does not give the judiciary sufficient time to be able to meet its obligations. So again, we will agree on how this money is going to be disbursed to the account or appropriated to the account. We can agree, we can have not quarterly, but after every half.
Honorable Judge, I want you to share with the Commission how you will be able to get that disbursement to the account. Which areas? Who are the people who are going to give you that? Whom are you consulting?
Oh, okay. According to the Constitution, the money is appropriated to the judiciary by Parliament.
Parliament, specific?
National Assembly.
National Assembly. Which organs are you going to engage in National Assembly?
There's a Budget Committee.
Budget Committee.
The Budget and Appropriations Committee. We also have the Finance Committee. I think those are the main ones. Of course, the overarching one is the Justice and Legal Affairs Committee.
Yeah, that is the Oversighting Committee for Judiciary. Very good. Before we leave that aspect, this is a hypothetical question. You are at liberty to answer it. In the event, for instance, you have your supplementary estimates, and the supplementary estimates, they are reviewed once in a while, and you find that one of your sub-votes, or maybe development budget, is more or less removed, or it's not there, it's not funded, and you have your projects going on and all those issues, and you are the chairperson of the commission. How will you resolve that issue? And I want you to see yourself as the chairperson of the commission and leave the accounting officer a little bit down.
Yeah, it would be very sad, because I think what should happen before any other amount is removed from your budget is to find out which are your priority areas. So without that, it would be unfair to simply remove. And because it's coming at the revised stage, I think you can, as the head of the commission, you can still engage the National Treasury.
Engage National Treasury?
Yes.
What level?
There's a Cabinet Secretary.
Oh, very good. Madam Chair, do you allow me to ask this question to the Honorable Judge? Now, different from finance, about codes, standards, norms and standards, service charter, that what you get in Nairobi is what you get in Nyuki, is what you get in Migori or in somewhere in Kware, in terms of the service that you give to the Kenyans in various stations. How will you ensure that that standard, norms, values that are given to Kenyans across the Republic is more or less uniform? One thing that you do.
Yes, there was a move towards this in standardizing all the operations of the courts, beginning with court buildings, depending on where they are. It's a very good thing because then the courts are the same, the people serving in those courts are the same. Something we were even thinking of in the Court of Appeal, having accommodation for judges in the 3 courts outside Nairobi. So when a judge goes there 2 years, they have accommodation, they don't start looking around for accommodation. So things remain the same across the country. But having looked at some of the buildings we are doing, talking about standardization, I do not think we have strictly followed that policy. You find huge courtrooms, court buildings in places where they don't deserve to be because the workload doesn't justify. And places where there's a lot of work, you have smaller court buildings. So we have not quite achieved the standards that we wanted to achieve across the country.
Okay. A question that I have more or less engaged the people who have been here before you: devolution and judiciary, delivery of justice and access to justice. Where did you get this position? Where you really place judiciary in terms of our devolution in our 47 counties, in terms of access of justice to Kenyans across the 47 counties? What kind of engagement framework will you have?
The judicial service is not devolved, but the judiciary has deliberately taken steps to go to the people. I know our dream is to have a high court in every sub-county.
Every sub-county?
I think that is the dream. Every sub-county, unless I didn't get it right.
No, it's a good dream.
Yeah, so we have a high court so that in every part of this country there's just judicial service. So engagement with the counties is in terms of assistance for land to put up courts.
Right, yes.
Yeah, but quite tricky though, because it will have to be done, of course, through the office of the Chief Registrar, because we know there could be some conflict of interest that you are given land by a governor who has a case in court and all those considerations.
But Council, Honorable Judge, the land does not belong to the governor. The land belongs to the county government.
But the perception, Commissioner, as we said earlier, that the minute you are seen in the newspaper receiving a title deed from a governor, it will be differently interpreted. Okay. And that's why it's a role that will be played neutrally by the court administration. But that's one area that the judiciary and the county governments can collaborate.
Okay. Any other area?
I know we've had issues with revenue collection in the counties. There ought to be a solution to it if it has not been resolved, because we provide the service of a magistrate to sit in those county courts. Initially, the issue was the revenue that they collect, but my concern is where they sit. Should they sit in the county offices, or should we have a separate court for our county magistrate, so that it is not seen as if they are part of the county government, but independent, but officers of the independent arm.
So what will be your recommendations to that, to solve that problem?
That we have accommodation in our courts for the magistrates who do county bylaws, so they are not mistaken. You know, the usual perception that you are now part of the county executive and not an independent. Because I'm told right now most of them operate from the county offices. At least I'm aware the longest county court has been Nairobi court, where we used to second magistrates to the council court.
Would you address yourself to corporate culture? The kind of culture is you come to the commission, the kind of culture that you like to introduce or to establish for judiciary, a culture that will be identified in the judiciary. What kind of culture would you do, corporate level?
A culture that focuses more on the customer.
Customer, very good.
We look at service delivery. That's the culture that I would like to bring, a corporate culture. We keep time, we don't waste time. I keep saying that I consider everybody working in the judiciary to be a shareholder in the judiciary, and we must behave as such. We must give the judiciary a corporate look from the way we do things. We must be receptive, and we must be sensitive.
Okay. Just before I head up, Madam Chair, Honorable Judge, I heard that you were allowed, is it 6 hats or 5 hats? I don't know how you're able to do those. If you are to wear those 5 hats, there is this principle of delegation of responsibilities. I mean, what is your experience and what skills are you going to use to make sure that you delegate effectively, but you don't abdicate your duties in those 5 hats or 6 hats?
Yeah, I think the main principle of delegation is you delegation to one level and get results. You don't delegate and go to sleep. You must give timelines for the results.
So in those 5 hats?
Yes. You want me to explain in each hat?
Yes.
Okay. The commission here, we have a very vibrant secretariat. We have a very able secretary. The commission itself has delegated some powers to the Chief Justice. Those powers cannot be delegated further. As a CJ, we have the Leadership Council, and then we have the leadership and management teams spread all over the country. So these are the channels that I'll use to do my work, to receive feedback, and to be able to render service effectively to the people we serve.
I was getting concerned because I think you had delegated some duties at that council. And when you're discussing that part, I did not get very clearly if those powers were delegated to you to share that council. Well, they could not exercise those full powers. I got the impression that halfway backwards. And that's what I was looking for. When you are delegating some work, because you cannot, the share is not available, you should be able to discharge all the responsibilities given by that. But the person who takes the buck is the person delegating.
Yes,
is that correct statement?
Yes, very true. That's correct statement.
Okay. Now, the other issue I would like us to talk about is establishing a structured engagement with the other arms of government.
With them? Sorry?
Establishing a structured engagement with the other arms of government, even the public. Would you maybe spend 1 minute or so on how you establish those structured communication strategies with the other arms of government and other agencies for that matter?
I see your question in two leaves, with the other arms and then with the consumers of our services.
Yes.
With the other arms, I said at the beginning that some of the challenges we are facing today would not have been there if we had structured channels of communication. Structured in the sense that the three arms of government must have a table where they sit and discuss nothing but how to make the arms function. Not to discuss merits and things to do with court decisions, because that belongs to the court. Although we are overly concerned about our independence, that we even fear having this table to sit with the three arms. We are overly concerned that there would be interference. I don't know how many cases come to the court from the executive or from parliament that would make us so overly concerned about this. It's less than 1% in my estimation. We should be concerned about the Wanjiko, the person who has this succession case that has been here for ages. We should be concerned about a land dispute that has been lying here for ages. And so that is a structure that I would recommend. And then, of course, outside, I think we haven't done very well in terms of communicating with the public. And so we are always misunderstood. We always rush to correct what we think has been misreported or the talk out there. We need to have a vibrant communication system.
Okay. Yeah, let's just maybe for 1 minute look at the table you have talked about in terms of the arms of government. If I have to get a chance to come to that particular table where the three arms are meeting, whom would I fight or who would be sitting at that table?
This table will be just the heads of those three branches.
Maybe you could break down for us.
Yeah, so there would be the head of state, who is the head of the executive branch, would have the two speakers for the other branch. And sorry, I'm doing the mistake people always do. Then I will say the judiciary last. I should have even started the judiciary, so that it's not seen as always being last. So the Chief Justice will be there on behalf of the judiciary at that level.
Very good. I've been here for 2 years, and I saw that kind of that table more or less. I think last year when you had the soldier statement here, and the statement, the address was made, books were shared, nice photographs taken. As a chairperson of the commission, and even as a member of the judiciary, would you get concerned that after the report is made public, what happens? What follows? Given the reports to the two speakers, you as a chairperson of the commission, what do you make really a follow-up on them? And if so, for what purpose?
I recall my speech during the soldier report launch, when I emphasized that we do this as window dressing. We have a beautiful glossy report. It is presented to Parliament. Parliament debates. We lose interest. We don't follow the debate. They make recommendations. We do not follow through. We wait for another year to do another soldier. And I was talking this in the context of the ombudsman being proposed in BBI. And I said one of the things Parliament had proposed in its report, having gone through, and they debated, if you look at the Hansard, they debated the soldier report the whole afternoon. And they made certain recommendations. But one, they said that the judiciary needs to now engage it, Parliament, to enact a law that will address the issues that our ombudsperson was appointed to address. And I said, had we seized that moment, perhaps people would not have thought of an ombudsman in the BBI report. But there was a very concrete recommendation by Parliament that we need to legislate this office.
And that brings me to my final observation. Then in that leadership council that you normally meet, those were not areas that you are of interest as a member of that council?
Commissioner, I said earlier that we do meet on need basis. Okay. So when COVID came, we met. When things escalated recently, again we met. But these are things that ought to be discussed at that level.
Thank you, Judge. Thank you, Chair.
Thank you, Commissioner Gishohi. Commissioner Kosgei, please go ahead.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, Commissioner.
Mine will be 2-3 questions. And I'm going to start with customer service. The public are still not satisfied on the kind of service that we offer, and yet we are here to serve them. And basic things that are supposed to be done, which many institutions did long time ago, 20 years, 30 years ago, on customer service, the positioning of customer care desk, training of staff, and signages, as you said, even internally, even in the buildings. And it is a problem in this kind of situation that we are in, especially when institutions have moved ahead. They are now in ICT world. They are not still thinking of human intervention anymore. So I wanted to know what kind of reforms will you bring or introduce to provide high quality service that is effective and efficient to the public, because that is the person that we need to be, serving. And bearing in mind that you've been here for 34 years, what is this that stopped judiciary from introducing or improving on its customer service? And what are you bringing in as reforms now so that we will be at par with other institutions of government?
Customer service and satisfaction starts with judicial work. We ought to be able to render our decisions as fast as possible. But I think the area you're concerned about is the soft ones, where you have a reception where litigants are directed. And I think to some extent this has been done in some courts. I've been to some courts and I've seen desks with people, though I've also been to others where there are only desks. In the Court of Appeal, we are in the process of, had it not been for COVID, we were going to have screens to display which courts are hearing which matters, before which judges. Something that runs like the one you see at the airport. We were also in the process, and it is something that we haven't given up on, even though COVID has come. Alerts, text alerts that we are doing closely with the ICT Directorate, where you are notified that your case is coming on a particular day. The third one, which perhaps may not be customer service, is the empaneling, digital empaneling of benches in the Court of Appeal, so that the President doesn't have the leeway of empaneling benches to take away any complaints of, say, bench fixing, and so we are working on those. But again, we need to, our communications unit, we need to revamp it so that we are able to educate the people we serve. I see there's something on our Twitter handle talking about issues of succession, family matters in court, educating people, but I don't know the outreach of that forum platform. I think we need to make our communications unit much more proactive. Currently, I can only give them credit for sending to us newspaper briefs after we have read the newspapers. That's all I think they are doing quite effectively, but they ought to engage much more to reach the people we serve.
Yes, I've been trying to reflect and try to find out why judiciary was left behind. You see, when I look at your CV here, you've been in very high positions from 1994 to 2004, where you were actually running the institution. And that was a period where issue customer service in government. You remember when the Dream Team came in, then issues of customer service came in. There was a lot of transformation in the country. Issues of ISO certification came in, and many ministries, departments, and institutions of government are certified. They have procedures which customer service is embedded. There was also ICT, which was rolled out, and the government was very willing to support them. Then the question that comes to my mind, and I'm asking myself, is what happened with judiciary? Is it really money? Because government then was ready. Development partners were ready. Was it the management, was it the administration of judiciary that did not see the opportunity and did not see the need to seize this opportunity of introducing, this new way of doing things? What really happened? And I think the best person to answer is yourself, because you are the accounting officer, the authorized officer.
I can't say that we were left behind, because there is no basis for saying that. The judiciary performed at that time. If you got people who are working in the judiciary, some will tell you that today there are things we were enjoying when I was in administration that is not there with the 17 billion budget. Show me any ministry, even with that ISO, that computerized until after 2010. It was all to do with the budget. And whatever we do with that little budget, there were things that were tangible, that were seen at the time. Judges were training, magistrates were training, paralegals were training. To our level, we were able to provide them the basics. Of course, it was all about budget, and even that budget we fought for to even get to 800 million. It was much less than that when we moved into administration. I wouldn't describe that period that the judiciary was left behind. We were the dream team that came. served everybody in the government, and the gains that were got from the dream team in the ministries, we also got, and there were results that were seen. But I don't think it is correct to say that things were so bleak, that things were so bad. We were able to work in this institution, and we were happy even with our little resources.
So the challenge was resources?
Resources.
Which was a problem. Thank you. Commissioner Mashari alluded to the performance of the institution in as far as operations is concerned, because we are both audit committee members and I chair the audit committee. And sometimes we are horrified to receive reports that shocks everybody in terms of loss of revenue. Even the deposits cannot be traced. Even register management, things that are mundane, things that should not be a problem now. And when you look at these deposit management issues, it goes back to about 80s, mid-80s. I wanted to understand, because we have not found time to get an insider who has been here for a long time. What were the challenges? What are these? What was the problem? To the extent now that we cannot even know. And it is about between 800 million to 1.2 billion that is hanging somewhere, that is not known where it is. Sometimes the officers blame district treasuries, the delinking issue. And I've seen that you are a member of the delinking committee in as far as the entire judiciary moving to be independent, sort of. What could have been the problem? Is it like we did not take care of deposits when we were moving to be independent, or was there, who dropped the ball here?
Thank you, Commissioner. At the time, all revenues collected in the districts were banked in the district. So a court in Mombasa that collects fine or some deposit would bank it in the district treasury in Mombasa. And even as we delinked, this is one area the treasury completely refused to let go, completely. Obviously, because it helped them in the districts to offset some of their commitments. So they were not ready to give up. I was actually very surprised that this thing is still persisting so many years, because we were able to move in Nairobi, although Nairobi was not affected. I think Mombasa was the second place where we were able to move out, and eventually we all moved out. But the problem is the money that was deposited in those districts. And this is where the challenge is to the Commission, that we must be able to find a solution, because people deposited their money, they want them. Perhaps some people have even died. And it's unfortunate that that huge kind of money would sit there. But again, if it has to be resolved, the National Treasury has to be in the forefront together with the Commission to be able to find a solution.
Yeah. Thank you. Let's go back to where Commissioner Gishoi, I think he touched on performance management. And it has been a bit of a problem, because we have what we call PMMU, something like that. And we've been having, or people come and dispute the data. the judges, the magistrates say, no, those are not my figures. I have my figures. I will come with my figures. To the extent that it seems like somebody somewhere is resisting measurement of their performance. So what are your thoughts on the introduction of performance management system within judiciary? And you see, what reforms will you introduce to entrench the performance management system so that each and every officer is accountable and no one will wait for a big brother to push him or her to perform what they are supposed to?
Thank you. Long history of performance management in the judiciary. When we try to introduce performance, we are told you can't measure the work of a judge. It involves a lot of complicated angles. And so when it came to pass, as it is something that I personally support, that you can measure any kind of work. And of course, I'm also aware that there are people who will say it doesn't reflect the truth. Whether to interpret that to mean that somebody doesn't want to be measured or that the directorate has not done a good job is something that, if I get a chance, I'll have to look at. I personally, in my court, we have been victims because sometimes they don't share with you in advance. But since we talk to the directorate, before they release the documents, they share with us and we confirm. Yes. And I think perhaps those who dispute do not look at what is brought to them as feedback to confirm the accuracy of those figures. I think it's upon all of us who are being measured that we take keen interest, because going forward, the place for performance management, in order to make everybody accountable, has to be looked at very, very seriously, so that those who have just placed their hands on the car are identified.
Thank you. My final question is on community service. I have seen that you are involved back at home, Usenge, a board member of a school, and you are doing a lot of mentorship across the country. Congratulations for doing that. And at the same time, you are caring for less privileged children, which is a good thing. What drives you? What drives you to do this?
Other than those, we have in our court also taken part in a lot of community service, CSR. We've been visiting children homes and we've been assisting. But it's my upbringing. As I grew up, our home was like a school. My parents were quite philanthropic. I didn't know who was my relative and who was just a person who was being assisted. After my dad passed on, my mother, I think because of being lonely, when we went to town, living in different parts of the country, she, with her philanthropic approach, started bringing children. Every time she went for a burial and the children are orphaned, she would bring them home. So by the time she was passing on, she had 12 children she was taking care of. So I inherited them, and it's because of that background that I saw the need to continue helping the society. Not most of us get to these positions we do take some of these things for granted, that you are a Court of Appeal judge. You are more privileged than somebody else. And if you have an opportunity to help, you help.
Thank you. My last. It is on this other duty to the community that Commissioner Washari asked you about, which we explained. The issue of serving as a reservist for 10 years. And between 1994 to 2004, you were principal, registrar to being High Court registrar, and you are a policeman, an inspector for that matter. And perhaps your commander was Robert Shaw, was called Shaw, somebody who was from Starehe, who was terrorizing people in this town. I think terrorizing criminals in this town. And I lived with one or two reservists where I stayed when I came to Nairobi. And apparently I realized that they had uniform. Sometimes at night, when their radios start ringing, they would move out with guns to do what they are supposed to do as policemen. Now I've been wondering, a deputy a High Court registrar in the Supreme Court, and then a raid is done here, and the Commissioner of Police knows that Corporal William Ouko is around there. Won't you? I don't know. I'm sure the call of duty demanded that you have to move in quickly and secure the place, so that when the regular police arrives, you have secured the place and you furnish, because reservists were furnishing, you cannot even know that they were around or not. Was a little conflict, because here you are a judicial officer, the other side you are a policeman who is supposed to enforcing the law and also arresting people to be brought to court to be charged. How was that? I don't know. If you reflect, would you have done the same?
Yes, I would. Because my mind is very, very clear why I was doing it. My mind is very clear about the limits. As I said, I had no police uniform. Only once in a while I would be asked. It was really just a title. I would be asked to go and give a lecture to the police officers. I would never get involved in beat duties to patrol. I would never chase criminals, and it did not interfere at all with my work. It was just something you do once in a while, the way I would be asked, as you've seen in my CV, to go and talk to students at St. Andrews, Turi, to go to talk to students back home, is something that I was doing to give back because of my knowledge of the law, to help the police understand their powers as they arrest, as they use their guns. But I didn't carry any firearm. I did not arrest anybody in my life as I served. It was really just to give back. And my concern was the many shootings that were happening, the many arrests that people were just being arrested, taken to Makadara. And so because I understood what was happening, I thought I was the right person to talk to them. But it's not something I really regret doing.
Very well, Judge. Thank you. Thank you, Chair.
Thank you, Commissioner. Thank you, Your Honor. Lastly, we have our last panel member, and that is Honorable Commissioner Evelyn Owande.
Thank you very much, Chair. Good afternoon, Judge.
Good afternoon, Your Honor.
Before I start with my questions, allow me to clear some impressions that may have been created by some comments that you have made. For starters, concerning performance evaluation for judicial staff, especially at the station level, we do have a system called PASS. the performance appraisal system. As to how objective it is, the jury is out there, but we do have one.
Thank you.
The other perception I wanted to address concerns the statement you made that magistrates are well remunerated, because we are not all on the same page on that. Yes, we do have incentives like the car loan, we have the incentives like the mortgage, but Judge, we have magistrates in the institution who from their take-home salary cannot even sustain mortgage repayments or a car loan repayment. So it doesn't cut across the board.
Thank you.
Thank you, Judge. So moving on to the question that I had for you, please share with us your views concerning abortion vis-a-vis the legal framework that we have.
That's a tricky one, because the views you express here will be held against you as you go ahead, and if an abortion matter was to come, your view is known all over the world. I can only say that the law says that life begins at inception, at conception, and you cannot terminate a pregnancy unless the life of the mother is endangered, and again upon the advice of a medical expert. And I would beg to leave it there. Whether or not I believe in it, that I leave for the day a dispute like that comes to court.
I hear you on that, Judge, but if I can take the discussion further, feel free to tell me if you feel you're not comfortable to respond to that. But I came upon a decision, the Fida Kenya case, that dealt with the issue of abortion. Basically, it was unpacking Article 26(4), but basically provides what you just said, the instances when abortion can be allowed. And the court essentially held that abortion can be allowed if it is a result, the pregnancy is a result of rape or defilement, and the pregnancy poses a danger to the mother's well-being, either physical, mental, or social. So the question that I had, in our sexual offences law, no distinction has been made in respect to the Romeo and Juliet relationships. There is a blanket definition of defilement that covers all, basically paged on the age of the victim. So would it be correct in your view to say that those many instances that we have of unwanted pregnancies that basically affect our school children, but born out of the Romeo and Juliet relationships, do you think we can legally procure abortion in those circumstances?
I'm glad you used the word legally, so therefore, if it is done within the confines of the law, yes.
Thank you, Judge. My next question, I want to pick from the statement you made earlier about your vision for the institution, restoring public confidence in the judiciary. We've been sitting here all morning, and even I think sometime in the course of this week, a candidate was here and presented his view concerning customer survey satisfaction. So rather, customer satisfaction survey. And apparently we are rated quite high by our customers. We've been transforming for 10 years. We have many success stories, but these stories are lost to the public. Earlier on, when the interview began, my lady, the SCJ, gave you some statistics concerning leadership in the judiciary. in terms of gender balance. It is all lost out there. There's still an outcry, if I can call it that we are not gender balanced. We have the SOJA report that we give annually, which has impressive statistics. But still there's some restlessness amongst the Kenyan public concerning judiciary's performance. From where I sit, it looks to me like there's a disconnect. I don't know if you agree with me.
Yes, I do.
Thank you.
I do.
So what do you think is the disconnect, and how do you propose to address this?
We are not talking to the people we serve. We are talking to ourselves in the way we write our judgments. We write Latin everywhere. We do great things, but nobody sees. So when you talk about the judiciary, it's just negative after negative thing. Yet there is so much that the judiciary has done. So what do we lack? We lack the means to tell the people what we do. We have recommendations in those very many reports that talk about pamphlets, that talk about TV shows, that talk about radio talks, that talk about many things. And I want to commend Chief Justice Mutunga for introducing the open days. It was a time when we would talk to the people across the country, a day set aside for talking to the people, for receiving feedback. That is something that we lack. So we need to look at the means of engaging the people we serve, which is really our focus.
Thank you, my lord. Earlier on, you mentioned that we need to revamp our public communication strategy. And I think you said on a light note that currently all they do is send you newspapers after you've already read the actual paper. Now, looking at the structure of that office or the capacity of that office, do you see maybe areas in which some improvement can be done? There has been a lot of disgruntlement amongst our membership that often you find your decision is misquoted in the newspaper. You have no avenue to address that. We have, I think it's now a Department of Public Affairs and Communication. Nothing really happens. So, since you are a member of this institution, is there a handicap or a gap you've identified in that office, and how do you propose to address it?
Thank you, Commissioner. Very true. We are misquoted all the time. Contrary to our decisions, the public are told different things. And it takes a judge or a magistrate concerned to call the newspaper itself or the media concerned, the media house concerned, to correct. There's one particular one that happened. I can't remember which court was concerned. There was a misreporting that was so grave. And the DPP spoke earlier than us, yet it was something to do with our decision. So the DPP clarified the position. It was, I think, a criminal trial somewhere in the country. By the time we were reacting, already it had been clarified. So I think the handicap, perhaps, apart from, I only see a few ladies in that unit, so perhaps a question of capacity, but another capacity of the kind of work we do as courts, quite technical, that if you do not have somebody who understands law, they'll not be able to respond to some of these misreporting. So one thing that perhaps the Commission should consider is to engage a lawyer to be part of this team, to engage somebody who has worked in the media to be part of this team, to be able to convey to the people what we do and correct any information that may be misunderstood.
Thank you very much, my Lord, because I think public communication is very integral in the services that we give, because I am aware that when the public is disgruntled, there are usually very grave consequences. I have in mind the vetting that we went through and the vetting that is currently, the talks about vetting that are currently simmering in the public domain. Now, moving on to the next question that I have, it concerns the disciplinary process. In the third schedule, paragraph I think 15 and 16, the Chief Justice enjoys certain powers when it comes to discipline. I believe mostly for judicial officers. It's the power to interdict and the power to suspend. And if you look at those paragraphs in the schedule, a lot is left to the good sense of the Chief Justice. You have phrases like "if in his opinion," phrases like "when he is satisfied," and you may be aware, my Lord, that this has caused a lot of unrest amongst judicial officers to the point where they had to litigate the matter in court. I can say they were partially successful because the issue of timelines was also litigated and some directives were given concerning having timelines in that framework. But the issue of how objective the power to order someone on interdiction or suspension is still remains unresolved. Now, as Chief Justice, what do you propose to do? Because these are going to be your subjects. What do you propose to do to put this matter to rest for your subjects?
Thank you. I was part of the team that worked on the Judicial Service Act. If you look at the task force report, it is an annexure and was the first thing Honorable Mutula Kilonzo tabled in Parliament to be passed as law, Act number 1. It was the first one after the promulgation of the Constitution. And so I understand where this provision came from. We were operating under the Service Commissions Act before we did our own Service Commission Act. And in the Service Commissions Act, the heads of those ministries were authorized to take certain steps preceding disciplinary action. For instance, the Chief Justice in the case of JSC, which was JSC was actually part of the Service Commissions Act. So on behalf of JSC, the Chief Justice could take certain actions, but escalate the rest after doing some investigation to the Commission itself. And so there is a basis and history for that. If I didn't hear any hue and cry at the time, I don't know what was being done differently, but if there is hue and cry, then perhaps the solution, because first I believe that looking at the areas that concern the staff concerned, interdiction, suspension, and of course reprimand and severe reprimand, are not disciplinary actions per se. They are processes leading to discipline. Just like in the Constitution, when a judge is to be removed and the president appoints a tribunal, then the judge is suspended. It doesn't mean that you cease being a judge. It doesn't mean that you have been found culpable. It just means like the stepping aside in the meantime. So for me, those are quite innocent things. The Chief Justice has no powers at all under that act to dismiss, because when it gets to the level of dismissing, he escalates to or he or she escalates to the commission. But if there is disquiet, then the best thing to do is the Chief Justice still exercises that delegated power, and perhaps could be assisted by a member or two of the commission. Remember, when the matter goes now for disciplinary action before the commission, the Chief Justice does not sit because he's already worked on the investigations. So perhaps get some people to sit with him so it's not seen as a one-man show or a one-woman show, so that it is seen a bit representative, even among the affected officers. If you can have, say, one chief magistrate, perhaps somebody from the staff, to sit with the Chief Justice as they sieve through these matters.
Thank you very much for your response, my lord. My next question concerns alcoholism. Alcoholism is a problem, I think, that cuts across all institutions in the public sector, and the judiciary has its fair share of those problems. Now, the debate is out there that alcoholism is not an indiscipline case. Alcoholism is a disease. Of course, there are those who believe otherwise. As Chief Justice, how do you see yourself going about this problem of alcoholism, because it is with us in the institution?
Yes, true. It is there. Excuse me. I don't think it's widespread, but I know it is there in the judiciary as well. When I was in administration, I used to treat it as a disease, because it is indeed a disease and it is actually treatable. And so instead of ruining an officer's career, terminating an officer's career because he is addicted, you can look for soft solutions, rehabilitation, because these are people with families, and that they are so attached to their drink. Is a disease, actually, and so I would not discipline a person unless it is so bad, and until perhaps he's stealing files, unless he's fighting with people at work. There will have to be something else other than just being drunk for me to deal with the situation.
Thank you, my lord. Now maybe we can move to the second part of my session concerning complaints. We received quite a few concerning you, but a lot of them had to do with the decisional independence, or rather your decisional independence. And we received your response, and the commission is going to consider your response. But even then, I just want to ask you a question. It's not only isolated to your case. We received quite a number of complaints concerning even the other candidates, especially the ones that are already on the bench. And a lot of them had to do with their decisional independence. I remember I attended the farewell function that was held right here for the former Chief Justice, and I remember I heard in your speech, you said something to the effect that judges are taking a lot of time responding to complaints, which ideally ought to be the subject of appeal. So I just want to hear from you what you think may be the problem. Why is it that members of the public keep coming to the Ombudsman's office, keep coming to the JSC, raising complaints which ideally are the subject of appeal, and what you propose to do to arrest that?
The system we have, the adversarial system in this country, a winner takes everything, and those who lose don't lose for nothing. They say the judge was seen. They will create a reason, and we Kenyans are bitter losers. Nobody, even when you know you have a weak case and you've lost it, and you know it was very weak, you will still be bitter. That's what adversarial system does. But again, there could be genuine cases where people must raise their concern with the commission. My problem is the commission should be able to know, as you have correctly noted, that some complaints, if you look at them, a person has exercised a judicial function at the magistracy level, perhaps misapplied the law. It is not for that magistrate to explain how he arrived at that decision. The person complaining ought just to go, and those things that he lists in his letter complaining about an officer should be his grounds of appeal. And so my concern, even as I talk to you at the farewell party, is that I know you do a lot of sieving. I know that if you are to do response to complaints, you do nothing else but respond to those complaints. But there are some of them, of course these ones were different because they were for this purpose, but when you look at them, things that happened in 2001, somebody can't even remember, even if you got the file. And you wonder, why didn't they appeal? So there are those complaints that I think the commission, by responding to them, by asking the judges to take time off their desks where they're writing judgments, the parties can be told in a very good language that they can pursue appeal. And I say this because we have had situations where the judges, some of the judges said, look, somebody wants me to explain how I arrived at a decision. Isn't that a trespass on my independence? I personally think that complaints must be received, they must be acted on, but there are frivolous complaints from vexatious litigants who will go to any length. You see complaints copied even to the International Court of International Criminal Court. You see complaints copied to The Hague, copied to everybody in this world. If you see that and you call for the file, and I believe you can be able to deal with that without asking judges and magistrates to spend all the time, because this will they'll keep coming. So that was really my concern, Your Honor.
Okay, thank you, my Lord. There was one complaint, though, that I think is important to raise with you so that we can hear your response. There's a litigant whose complaint is that they spent 15 years in the High Court looking for justice. And finally, when the matter was concluded in the High Court and an appeal was filed, they have never gotten a date for the appeal to be heard. The appeal apparently was filed sometime in 2019. And the complainant, if I can call him that, was raising questions about your competence to serve as Chief Justice. Because much as the matter is not before you, the matter has delayed in your registry. What would you say to that, my Lord?
2019, that's when the appeal was filed. If I got there, I don't know whether that's one of those that I responded to. Yes. So it is true, we have 2019 appeals pending, and it's not one. And for the reason I'll say for the upteenth time, we can only constitute 3 benches, at most 4 benches. And this has to be known, that although the court is ready to work, we had actually planned when we met in June 2018 that we would be a real-time court, that would come to Court of Appeal and within 1 year you will be heard. Because we knew we were getting 11 judges. And when we looked at the people this commission chose to come to that court, we were excited because there are people who are not coming to be trained. There are people who have been tried and tested. And so this stalemate has a very serious ripple effect on the Kenyan people. It has serious effect on our investment and the growth of our economy. And so the answer I would give to the person who wrote is that we shall reach that case and it will be dealt with given our numbers. I can't assure him or her that that case will jump over those that have been waiting also, but we have a system that we use to hear these cases, and because of the numbers now, we cannot hear all the cases that are deserving to be heard.
Thank you, my Lord. But speaking on behalf of the complainant, maybe I can make a plea that you consider prioritizing their case, because from what I was able to gather from the complaint, the case involves retirees, some of whom are beyond 75 years, some have even died. Maybe you would consider in those circumstances to prioritize that particular case.
Thank you.
Judge, I was listening to you talking about the wealth declarations, and I knew that positive talk must have been coming from somewhere. I have looked at your application documents. The vetting bodies have cleared you. I have looked at your wealth declaration. You have filed for your spouse, you have filed for your child under 18 years. I really have no issues with your wealth declaration. I think they are meticulously filed. But even then, I would like to ask you, because from this response you are giving when you're talking about the wealth declarations, you said in support that there is a purpose they were meant to serve. And to me, the wealth declarations have an aspect of a lifestyle audit of sorts. And as I conclude, I just wanted to ask you what your views are concerning introducing that mechanism in our institution, the lifestyle audit.
There's a bill, Lifestyle Audit Bill 2019, very elaborate in the Senate. And there was a time all politicians were talking about, not all, some, about lifestyle audit. Hence this bill. It was going to be the framework upon which even the judiciary was going to ask members of the judiciary to be audited. Unless, because Kenya today, everything is being challenged in court, it is not something you can just introduce without any basis. Although when I was looking at the three statutes I talked about, the basis of the wealth declaration, perhaps nothing stops us from testing the waters. If we are really serious that we want to talk about corruption, and you think that the only way to talk about it and reduce it or reduce the perception is to audit us on how we live. If it can be done, then perhaps we have to look for a framework for it.
Thank you very much, my Lord, for your patience. I wish you well. Thank you, Chair.
Thank you, Your Honor. Thank you.
Thank you, Commissioner. Your Honor, as you know, we are required by the Constitution to take into account diversity. So I'll come back and ask you to please let us know your county.
Yes, I come from Siaya County.
And the ethnicity is?
It's Luo.
It's Luo. Thank you so much. And this brings us to the end of this session. Honorable Judge, thank you very much for availing yourself and for answering our questions and being very open and very candid about your answers, Your Honor. So I want to thank you.
Thank you.
And just want to ask you whether you have anything to tell the Commission.
All right. Just to really thank you for this opportunity and acknowledge the elaborate process that this has been, the excellent preparations, the communication with candidates, everything has been quite smooth, and I congratulate the Commission. It's given us an opportunity to have an open debate, a discussion where you are able to evaluate all of us and to be able to give Kenyans the CJ they deserve. And I just want really to thank you. But I just wanted to ask one question, whether there's anything that the Commission thinks like a magic wand that can propel, one thing that can propel this judiciary to the level that you wish, given the kind of questions that you have asked me.
Oh, you want us to answer that, Judge?
Sorry, I have turned the interview the other way.
I would request Honorable Judge Majata to answer that on behalf of the Commission.
Thank you very much. Our expectation is that every candidate will come with a magic wand and wave it at us. Thank you.
Well answered. Thank you.
Thank you very much, Your Honor. That is the end of the session. Have a good afternoon.
Thank you.
You are watching TV 47.